Good evening, everybody. Welcome. So for those that might not know me, I'm Jeff Brazel, and I am honored to be your mayor this year. In Morris Township, the mayor gets selected every year by the Township Committee. We don't have an elected mayor, we have an appointed mayor. So I was appointed by my fellow committeemen to be, or committee people I should say, because we have committee women, committee people to be your mayor this year. First thing I want to say is that even though there are people from the Township Committee here tonight, and there are people from the Planning Board here tonight, and there are people from the Board of Adjustment meeting here, Board of Adjustment here tonight, this is not an official meeting of any of those three bodies. It's just an informational meeting for the public. It's just a public information session. So I just want to be clear about that. I am very pleased to be holding the education session. One of the things I talked about when I ran for election is community involvement, educating the community, making sure they know everything that goes on, being transparent, and getting resident input when we need to make decisions. So having an informed community is the first step in in educating the community to ask the proper questions when we do have hearings at the Planning Board or Board of Adjustment, or a redevelopment hearing. If you were here at 5:30, we talked about a possible redevelopment hearing before the Township Committee for a property on Mount Kimball Avenue. So we had a wonderful information and education session last week on e-cigarettes and vaping, and it was a really great session. We had a lot of good feedback from the public, a lot of good questions that were asked that helped formulate, in my mind, some ideas, and I welcome at the end of the night to hearing the questions that are asked of you, because we're here to represent you, and your feelings about development in the town should be reflected in what we do on the Township Committee and the Planning Board. You'll hear the Board of Adjustment is an independent body, so we can't influence those, but you'll hear more about that from Steve. And I think with that, I will hand it over to our professionals. So I just want to introduce Steve Warner is our Planning Board attorney. Richard Aller is our Board of Adjustment attorney, and Paul Phillips is our planner. And right down here in the front row is Jim Slate, who is our town engineer. And if everybody hasn't gotten a handout, there's handouts in the boxes up here. So if you don't have one, please grab one. And those are the slides that are going to be reviewed by Steve right now. So I'll let you, Steve, take it over. Thank you. Thanks everybody for coming.
Thank you very much, Mayor. Good evening, everyone. As the Mayor said, my name is Steve Warner. I'm a partner with the law firm of Ventura, Meisowitz, Keough, and Warner. The vast majority of my practice is in the area of municipal land use law. I represent zoning boards and planning boards and serve as special redevelopment counsel and special land use counsel to several municipalities throughout northern and central New Jersey. I am privileged to be and have been for several years now, the planning board attorney here in Morris Township. And I am also privileged to be, like you, a resident of Morris Township. I have with me my colleagues directly behind me, as the Mayor said, Rich Oler, the Zoning Board of Adjustment attorney from the firm of Oler and Breslin, as well as Paul Phillips from the firm of Phillips and Price. Paul is our township planner and also serves as the professional planner for both boards, the Zoning Board of Adjustment and the Planning Board. And the genesis of this session was something that I've been doing for about 20 years now. I also serve as the associate counsel, one of the associate counsels for an organization, the NJPO, New Jersey Planning Officials, a group of engineers, planners, and lawyers in the municipal land use field. And one of the many things we do is we teach the certification course for all new zoning and planning board members, as well as more experienced board member courses. And one of the things I do in addition to doing that is make it a point to periodically teach my own abbreviated version, if you will, to the boards that I'm privileged to represent. And in discussions with the mayor and Deputy Mayor Wilson, we decided why not broaden the educational session that we do for our board members, for the public, so that everybody can be fully informed on the process, and it only makes it for a better process collaboratively and participation-wise if everybody who's involved, all stakeholders, all neighbors, all members of the public, understand the process. We'll try to make it interesting. It might be a little dry. You got lawyers and planners, so we'll do our best. But that is the purpose, that is the genesis of this presentation. I will ask a couple of favors. One, I'll ask you to hold questions until we're done. There's a lot of material we hope to get through, but we will stay for questions and answers. I suspect I can speak for my colleagues. I'll speak for myself. I'll stay as long as you'll stay here to ask the questions. I'll stay here to answer them. And also we will, when we do the questions, we may have to limit, we cannot discuss matters that are pending before our respective land use boards because there are rules that you'll hear more about that require certain questions and information only to take place during public hearings on those separate applications. But we'll do our best to answer as many questions and every question if possible as best we can. So I want to get started. I hope everybody has the handout because it is verbatim what you'll be seeing up on the screen, or the wall I should say. We're going to start planning and zoning boards with an overview. And this first chart is something, it's the only thing that I did not prepare, so I can't take credit for that. But it's something that Deputy Mayor Wilson was familiar with and I'm familiar with from our NJPO materials. And it's a very general, broad-based chart of how the process works. And then we'll get more into detail as we proceed. Land development regulations start with planning on the first column. Members of the community, residents, elect the governing body. The governing body, our legislative branch of our municipal government, appoints planning board members and zoning board members. In particular, the mayor appoints the majority of the planning board members. The planning board prepares a document, and it is the document. It is the municipality's, our township's master plan. I liken it, it's not a great analogy, I'll readily admit, but I liken it to sort of the Constitution. It is a very broad-based document with goals and objectives for how we wish as a township to develop throughout our township and in various areas of the township. It has studies, demographics, a lot of historical information, and overall sets forth through the statement of objectives and various other elements our vision for land development in our township. And it is periodically updated at least every 10 years, which I'll talk more about later. Beyond planning, we have the adoption of land development regulations. That happens at the governing body level, the governing body with land development ordinances. And when I refer to land development ordinances or regulations, I mean zoning ordinances, subdivision ordinances, site plan ordinances. Like all other municipal ordinances, the Township Committee introduces them at first reading. Then it is, the land development regulations are referred to the Planning Board for consistency review with the master plan to make sure that those regulations are consistent with our Constitution, if you will, the master plan. And then they are ultimately adopted after a second reading at a public hearing, as many of you may be familiar. The ordinances implement the goals and objectives of the master plan in a very specific way, including with respect to what types of development are permitted or not permitted in various areas, zone districts, as well as bulk regulations, how far things can or must be from each other, how much coverage can be on a lot, and the like. We have a zoning map, our zoning ordinances, our subdivision, our site plan ordinances. Those are all that's the body of municipal regulation of development of land here in our township, like every other of the 565, if I'm not mistaken, municipalities in our state. We also have something called the Municipal Land Use Law, which is the state law that is the umbrella, if you will, legislation that governs all that we do at the municipal level with respect to land development. And then there's the implementation layer or level. Implementation of these land development regulations primarily occurs through applications, and you've probably all been aware of or seen or maybe been involved in land development applications, either applications by a property owner or someone with an interest in property, homeowner, real estate developer, commercial business entity, bringing an application either before the planning board and the zoning board. And if we don't accomplish anything tonight, and I hope we accomplish much more than this one thing, but hopefully you'll come out with a better understanding of why do some applications go before the planning board and some before the zoning board. But we'll get to that, and I'll keep saying this, we'll get to that in a little while. But very generally, the answer to that question is if applications for development of land generally are consistent with the zoning ordinances and the master plan, and in particular don't involve something that we call a D variance, a use variance or a D variance, then it is likely that that application will go before the planning board, the board that I'm privileged to represent. And sometimes the planning board is referred to as the board of permitted uses. If the application has variances, in particular D variances, which again we'll talk about later, those types of land development applications go before the zoning board of adjustment, and Rich Oller gets the privilege of representing the board during the hearings on those applications. And if and when an application is approved, undoubtedly the application will have many conditions of approval, conditions generally being restrictions, requirements, terms, and conditions that minimize the potential detriment of the development of the land. For example, compliance with certain environmental obligations, stormwater regulations, and the like. Those will be listed in the condition of approval, and after the approval, whoever is the applicant who's received the approval will have the ability or I should say the responsibility of complying with all those conditions, and that compliance and the enforcement of those conditions and the enforcement of the approvals is primarily handled by the administration under the authority of the governing body, and we have a construction code official, we have a zoning officer, Dave Hansen, our construction code official is Albert Master Batista, and we have a municipal engineer, Jim Slade, all of whom are involved from the administration in the enforcement of land development and in particular the approvals of the zoning board and the planning board. If we can go to the next slide. Still talking about the boards generally, but getting a little more specific. Again, I refer to the planning board sometimes by analogy as the legislative, along with the governing body, the township committee, a legislative and policy-making arm of the municipal land use process. The zoning board of adjustment I like to think of sometime as the judicial branch. They are a quasi-judicial body. They hear more applications than even the planning board does. And there's also, you may be familiar, certain municipalities, usually smaller municipalities, have a combined board, sometimes referred to as a joint board, consolidated board, or just simply a land use board. And all that board is a planning board with the additional powers of a board of adjustment. Board members are volunteers. Please remember that. They are not compensated, and they are serving the public interest on a volunteer basis, primarily in addition to all the other knowledge and experience they have, to be the citizen resident finders of fact in land development applications, to represent you and your interests in a global sense, in a broad sense, as a municipality and as neighbors of perhaps the development that is development application that is being heard by the board. They're residents of the municipality. You'll hear there's a class system, not in the old-fashioned sense, but the planning board has class 1, 2, 3, and 4 members. There is a class 2 member that may not be I'm sorry, can we move to the next one? You didn't move, sorry. My bad, I didn't give you the signal. Class 2 planning board member. The Class 2 planning board member does not have to be a resident of the municipality. Our Class 2 planning member is Jesse Carr, the fire official. He is a resident of our municipality, of our township. And all the board members, as I alluded to earlier with the course that I and others teach, are required within the first 18 months of their being appointed to the zoning or planning board to successfully complete the required course. With two exceptions, the Class 1 or mayor's designee does not have to take it, nor does the Class 3 governing body member of the planning board have to. Our Class 1 planning board members and Class 3 members have and continue to take the course, notwithstanding that it's not required. Next screen. There are basically two competing principles that get involved in every aspect, in my opinion, of the municipal land development process, and that is the rights of property owners to develop their property, be they an owner, a tenant, what have you, or and on the other side, the competing tension, the competing interest to balance with that property owner's right to develop their property is the right of the public to enjoy their own property and not to be have their neighborhood substantially detrimentally impacted by the development of somebody's land, their lot. So, and another general principle is bringing property, you'll hear this in land use law, bring property into conformity, meaning make it conform as best as possible with the zoning requirements for that lot in that zone district as quickly as is compatible with justice. Okay, so people have property rights. They may have had the property may have been a certain way for a long time. They may have what's called a pre-existing non-conforming situation on their property. They can't lose those rights. But under certain circumstances, those rights can be impacted over time and with the ultimate goal of getting properties and development on properties to be as compatible and conforming with the zoning requirements of our township. And all applicants have a right to file. If a property owner, tenant, commercial business wants to bring an action, they have what we call legal standing to bring an application for development before the Board of Adjustment and the Planning Board. It's not the discretion of the board or the township to say, okay, we'll hear the case, or no, we won't hear the case. It is mandatory that the board hear the case. There are times perhaps when somebody may say, why is the planning board hearing that case? Well, the answer very simply is the planning board is legally obligated, or the zoning board is legally obligated under those circumstances to hear the case. They must, regardless of what might be the merits or lack thereof of that application. So please remember that. The planning board itself, the Board of Permitted Uses, we're going to run through very quickly, or as quickly as I can. Planning boards have 7 or 9 regular members. We have 9 regular members of our planning board, and up to 4 alternates. We have 2 alternates of our planning board. All the members are appointed by the mayor except for the Class 3. I know I keep saying I'm going to get to it. I'm going to. The different classes. The Class 3 member, who is a governing body member, that governing body member is selected among his or her fellow governing body members as to who serves as the Class 3 member of the planning board. Next, there's our class system, as I say. The Class 1 is the mayor or the mayor's designee. The mayor can designate any resident to serve in his or her capacity. Our mayor serves himself as the Class 1 member of our planning board. The Class 2 member is a municipal official other than someone on the governing body, other than someone on the township committee. We have, as I said, Jesse Carr, the fire official, serving in a long-standing capacity as our Class 2 planning board member. Class 3 governing body member, I may have mentioned Deputy Mayor Wilson was selected amongst the governing body and serves as our Class 3 planning board member. And Class 4, everyone else is a resident of the municipality, not a municipal official, or not on the governing body, on the township committee. Excuse me. Moving on, we have Officers, the chair and the vice chair, are selected from the Class 4 members. You can see perhaps how it works. We have a representation from the governing body, but this is not an arm of the governing body. The planning board and the zoning board are separate, independent, autonomous bodies, notwithstanding that a member or two of the governing body are statutorily on the planning board. We have a board secretary, board attorney. The township attorney, the municipal attorney cannot serve as the planning or zoning board attorney. Planners like Paul Phillips, engineers like Jim Slade, traffic consultants, and we have our own board rules, or sometimes referred to as bylaws. And a lot of this is shared with the zoning board as well. When I say shared, I mean the same rules apply. Next, the meetings. We have meetings at least once a month. Special meetings can be called for. We have an annual schedule that's published in 2 newspapers at the beginning of the year. And all meetings are subject to the Open Public Meetings Act. They are publicly noticed and open to any and all to come and participate. There's additional notice requirements for the applicants often to give specific notice in the paper for their specific applications, as well as to oftentimes give notice to property owners within 200 feet of the perimeter of their property as well, those most affected generally by whatever it is the applicant is doing on their property. In order to act officially, a quorum for a 9-member planning board such as ours is 5 members, a majority, to act. If we have no quorum, we can only do one thing, and that's a motion to adjourn to a specific date and time next time, and hope we get at least a quorum. In my experience, we've always had much more than a quorum, because we're blessed, frankly, to have board members that not only volunteer their time and efforts during the day as well as the evenings that we meet, but the attendance, frankly, is astounding. And minutes are kept of all the meetings. Moving to some of the responsibilities of the planning board. As I said before, we have a master plan. The planning board are the gatekeepers of the master plan. We adopt the master plan. The master plan is not an ordinance. It's not adopted by the governing body. I'm getting a little paternal, I guess. But the planning board adopts the master plan. And that's done, of course, in a public meeting and a public hearing. What is the master plan? As I said before, there's several elements of this guiding document. There are 3 that are mandatory. Oftentimes people will say there are 2, but then they realize that the housing plan element is also mandatory, so there are 3. The statement of objectives is mandatory. That is the broad laying out of what our objectives, our guidelines are, our vision is as a municipality and a planning board for development going forward. The land use element, have a lot of demographic information, but also showing existing and proposed development and the relationship between the various zones. The population density and other information is there, again, with together with policy and objectives. Also, our land use element must have, as of relatively recent legislation, a statement of strategy concerning smart growth, storm resiliency, and environmental sustainability. And the third mandatory element is the housing plan element, which includes low and moderate income housing, affordable housing, which has been a topic of much action and activity in the last few years, as you're probably all well aware. And in fact, we had back in the fall, we had a seminar or a presentation solely on the affordable housing situation and what our township was doing with respect to same, and Paul spoke extensively at that time. Now I'm taking my chance, I guess, Paul. But we'll hand it back over to Rich and Paul later on, I promise. The other elements, optional elements, a circulation plan, road and transportation facilities, things like complete streets, bike paths and the like, utility services, community facilities, recreation plans, historic preservation, all optional, all elements, most, if not all elements, frankly, we have, and we have more as part of our master plan. Next. The procedure for adoption, as I mentioned before, the plan is adopted and all the elements are adopted and all the elements are amended at a publicly noticed hearing. And the County Planning Board, the State Office of Planning Advocacy, and the clerks of the adjoining municipalities, all the municipalities that border our township, receive notice that we're adopting or amending one or more elements of our master plan. Why? Because everything is, the objective at least, is to interchange, interwoven. We want to be consistent with what's happening at the county. We want to be consistent with what's happening at the state level and vice versa. And as you can imagine, adjoining municipalities have an interest in what we're doing in our township land development-wise, particularly when we get close to their borders, as do we, vice versa. And we pay very careful attention when our adjoining municipalities are making changes to their master plan or to their land development ordinance. We review all of them as a planning board. The planning board, by statute, the municipal land use law, must be re-examined, reviewed, updated at least once every 10 years, and we recently did it, I think it was a couple of years ago, if I'm not mistaken. And we've been in the process of, and we always are in the process of, implementing what we, the changes we've made to our master plan, through our master plan re-examination. In addition, we do at the planning board hear applications. Often they involve site plans, which are those big engineering plans that Jim is an expert on. You've probably seen them. I have them in my briefcase, which I left in the other room, I candidly admit. But you're probably familiar with what they look like. They have key maps. They have the list of who the 200-foot property owners are surrounding from 200 feet the perimeter of the property, the lot or lots that are at issue being developed, lot line dimensions, all the location of all the existing and the proposed buildings, structures, and the like, the topographical conditions, slopes, etc., where the parking is and loading spaces are for a commercial development, landscaping, lighting, all the issues that as a community you are interested in, and particularly if you are an affected neighbor, most affected neighbor within 200 feet, like we are very interested in. The county planning board gets involved with the site plan review for commercial or industrial facilities. They have approval powers for multi-family developments. The county has approval powers. You'll hear a lot of times our planning and zoning board approvals would be subject to many conditions, one of which always will be all other required approvals, which often include the Morris County Planning Board. Other land development requiring off-street parking, land development providing a certain amount of surface, or resulting in a certain amount of surface runoff, stormwater runoff. All those properties located along county roads, they have approval. The Morris County Planning Board has approval powers. In addition, we have minor and major subdivision, site plan approvals, dependent on the type of development, the magnitude of the development, and whether or not also we may have a new street involved or an extension of off-track improvements beyond the lot itself. All those things will turn a site plan from a minor to a major. And when we have major site plans, you'll hear the terms preliminary or final major site plan. Really the major takeaway there is how long the applicant who gets the approval has to lock in the protections afforded to them, what they're allowed to develop and how, for how long. If they are at the preliminary site plan stage, they could lock that in for 3 years, but then they have to, unless they get extensions, they have to get their final site plan approval, in which they can then have another 2 years to maintain those protections, those terms and conditions, and the rights to develop the way the board allowed them to develop. If they don't, they lose those rights. And most times nowadays, frankly, the preliminary and final are done at one time. Moving on, we have conditions of approval, as I mentioned. The goal with all conditions are to minimize the detriment associated with the approval. Why? Because any site plan exception, boy, I'm too tall for the microphone, that's the first. Any variance, by definition, has some detriment associated with it, because the governing body, the planning board, who established these regulations, these zoning and planning and site plan ordinances, we've set the standards, the uses, the setbacks, the heights at a certain level for a reason. So any deviation, any difference, any exception, any variance from those regulations, by definition, there's something detrimental to the neighboring, to the neighborhood. So the conditions are there to mitigate, minimize those detriments that are associated with any development that is not fully conforming with the ordinances. Subdivisions are what you thought they were, if you didn't already know, dividing land. Parcel into two or more parts for sale or development purposes, and most of the time subdivision applications, like site plan applications, are before the planning board. Some of the key issues and objectives when you're addressing a subdivision application, generally to ensure safe water supply, adequate sewerage, emergency vehicle access. It doesn't hurt that we have the fire official as our Class 2 planning board member involved in the process, and other issues. And all subdivision applications, not just some, are submitted to the Morris County Planning Board for review. But if the application affects a county road or a county drainage facility, then the county planning board not only has the ability to review the subdivision application, but they have the authority to approve or disapprove the subdivision application. Moving on, again, there's minor and major subdivision approvals, and preliminary and final major subdivision approvals. If it's three or more lots, if it's more than 3 lots, or if it's more than 2 lots, not fronting on an existing street, then you have I'm sorry, 2 or more lots, not fronting on an existing street, then you have by definition, a major subdivision. Moving on, denials. Something else that's probably important to remember, you may see that most planning board applications are granted. Many, if not most, planning board applications are for site plan or subdivision approval and are either fully conforming, there's no variance whatsoever required, and may not even be any site plan or subdivision exceptions required. There are limitations. There are cases, frankly, where the planning board does not have the discretion to deny the application legally. And I cite the case that most people who are in the business know stands for essentially that proposition, the Pizzo-Manton case. So you can see why conditions of approval are critical, in my opinion. Site plan and subdivision exceptions. We're going to get to variances in a little while when Paul gets an opportunity finally to speak. But the site plan exceptions and subdivision exceptions, we have a zoning ordinance, and anytime somebody doesn't comply with something in the zoning ordinance portion of our land development regulations, that is a variance. But, bring the other hand over. When in our site plan and subdivision ordinances, anytime the applicant does not comply with those requirements, it's not a variance, it's what's called an exception or a waiver. The standards are a little less, it's a little different, but it is something that it is relief that the applicant has to get generally from the planning board when they bring that application to the planning board. And the standards, well, you see the standard there. It's, we lawyers like to use a lot of words. But the bottom line is if it would exact an undue hardship because of something peculiar about, unique and peculiar about the land, it would exact an undue hardship on the applicant to have to fully conform with that site plan or subdivision requirement. If they can prove that to the board, then they get that exception or waiver. Conditional use applications. I said we have a zoning board. And I said if you don't comply with, a zoning ordinance, and if you don't comply with the zoning ordinance, you need a variance. But there are different types of uses in the zoning ordinance. It'll have a list of permitted uses. The applicant can do that and does not need a variance to do whatever that permitted use is on their property. But there's something called conditional uses, and as the words would indicate, you're permitted as a property owner to use the property in a certain way, but, and there's the but, only if you comply with the conditions of that conditional use. For example, there may be, and I'm just making this up and I'm not good at making them up, I apologize, but you may have an ordinance that says gas stations are a permitted use in this zone as long as they are at least 300 feet setback from the nearest residential zone. If somebody comes in for a gas station to have a gas station use, construct a gas station, and they comply, they move 300 or more feet setback from the residential zone, then they have a conforming conditional use. That application would come to the planning board. No variances for it, and essentially the planning board is making sure, indeed, that they meet all those conditions. And by the way, the planning board is going to add a whole bunch more conditions too, in the resolution of approval within the authority of the planning board to do so. If they don't, if the applicant does not comply with every one of the conditions for that conditional use, they have what's called the D3 variance. You'll hear more about that later. Not the planning board, the zoning board. We make recommendations for zoning ordinances and amendments to zoning ordinances. As I mentioned earlier, when the governing body adopts an ordinance at a first read, they have a first reading, they introduce a land development regulation, a zoning ordinance, site plan, or subdivision ordinance on first reading at the township committee. They then must refer it to the planning board, the gatekeeper of, and the keeper of the master plan. And we have, as a planning board, 35 days to take that referral, review the proposed first introduced land development ordinance, zoning ordinance, site plan, subdivision ordinance, to make sure it is consistent with our master plan. And then we report back to the governing body through a resolution whether it is or is not consistent. And thereafter, the governing body proceeds with the second reading public hearing. They can do it without getting into all the details. They can do it even if the planning board finds that the ordinance is inconsistent with the master plan, but there's a little extra majority, if you will, and a rule, a special resolution of reasons why they did it, that the governing body, the township committee, must undertake in order to adopt a zoning ordinance, site plan, or subdivision ordinance after the planning board found it to be inconsistent with the master plan. There's capital improvement projects, and the program essentially, if there are capital projects involving expenditures of any public funds, incidental to the location, character, or extent of development, that's referred to the planning board. We do a similar review for master plan consistency for capital projects. It even includes school board expenditures for projects under the auspices of the Board of Education, but they are regulated by the State Department of Education. So the planning board for those reviews, you may have heard the term courtesy review. I don't like that term, frankly. because they're not coming to the planning board as a courtesy. They're coming to the planning board because they're required by law to come to the planning board, the Board of Education, when those expenditures are made and the development is proposed to take place. But I guess the courtesy part comes in because the planning board can't say no. It's not an approval, a role that the planning board plays when the Board of Education comes for school projects, development projects, to the planning board. Our review as a planning board is strictly recommendatory. So no conditions, no approval, just recommendations. Next, we have planning variances. You can hear about the C's and D's variances, but there's one other type of variance, and that's called a planning variance. It's somewhat technical, but the essentials are if somebody is developing without direct access to a public street, an official and fully improved street, then they're going to have to come before the planning board, if that's their only variance, in order to get relief. And as the statute says, they have to establish that the refusal to issue the approval would entail a practical difficulty or unnecessary hardship to them, notwithstanding the fact that their development does not front on a publicly recognized street. It may be that there's a street there, but you probably heard the term private road or an unimproved street or a paper road. They have to establish that, or they have to show that the circumstances of the case do not require the building or structure to be related, have direct access or front the street. And there's one other aspect under another section. They have to establish, the applicant wants to develop not fronting on a public street, that they can provide adequate access for emergency firefighting and other emergency vehicles necessary for the protection of the health and safety of anyone on that property. And they also have to show that they protect any future street layout on the official map. So there's a relationship between the general circulation plans and access throughout the municipality. And frankly, I just turned to Paul Phillips for that one. And now I'm going to turn to Rich Oler because we're up to the Zoning Board of Adjustment.
Really well done, Steve. Thank you. So as you heard, I am Richard Oler, and I'm the attorney for the Board of Adjustment in Morris Township. And while putting some of the materials together and looking at a few things, I came to realize that I've been representing the Morris Township Board of Adjustment since 1997. So time really flies, for sure. So Steve has just told you about the planning board, and that is the board of permitted uses. I'm going to tell you a little bit about the Board of Adjustment, because the Board of Adjustment handles the hard applications, the uses that aren't permitted. And they are pretty hard because they're not permitted by zone, and yet there's all kinds of case law that talks about when you should be permitting those non-permitted uses to occur. So you can go to the next slide, thanks. So how do we even get to have the Board of Adjustment? Well, the board members are selected in Morris Township by the Township Committee, and in Morris Township there are 7 regular members and there are 2 alternate members. The regular members, the term for them is 4 years, and the alternate member term is for 2 years. I'm going to the next slide. Thanks. So there are certain procedural items that have to be adhered to by the Board of Adjustment. One is that we have 1 meeting a month, and in Morris Township, the Board of Adjustment meets on the 4th Monday of every month, unless it's a holiday, and then generally it's the Monday before that. Special meetings could be called by the chair or 2 members of the board, but typically what happens is if the agenda gets pretty heavy, and there's a lot of applications to be heard, an applicant oftentimes will ask for a special meeting for which they pay some fees for that. And to the extent the room's available and board members are available, that could be accommodated by the board, and that does happen on occasion. Also, procedurally, in order to have our meetings, the meetings have to be posted and published, and they are put in the official newspaper of Morris Township, which is the Daily Record, and I believe the Morris News Bee as well. And then our meetings are also noticed as required under the Open Public Meetings Act. So since we have 7 regular members, the alternate members don't count towards a quorum. Since we have 7 regular members, there is a quorum requirement to have 4 members present at the Board of Adjustment meeting in order for us to be able to conduct business. And it's the same as what you heard with the planning board. If we don't have a quorum, the only thing we can do also is to just adjourn to a new meeting date. And for all those years that I've been here, I can't ever remember not having a quorum for business. We do, in Morris Township, we don't really have work sessions with the Board of Adjustment. If we did, they would be open to the public, but our meetings are generally pretty heavy with applications, and all of our meetings are really not work sessions, they're actual business sessions where we hear applications. And the board secretary does do the minutes of all of the meetings. Those minutes are ultimately approved by the board, and once they are, they're public documents and available to the public as well. And then here on the next slide. Okay, so statutorily, the Board of Adjustment really can only do what it is permitted to do by statute, and that's 4 main areas. The first one is what's known as Section 70A of the Municipal Land Use Law, and that is to hear appeals from the zoning officer. So if you were to go to the zoning officer or the zoning department and ask for a permit to do something, say to your house, and it was denied for whatever reason, and if you thought that decision was not correct, you could appeal that decision, and that appeal would go to the Board of Adjustment. There's no notice requirement, by the way, for that type of appeal to the Board of Adjustment. Then in, pushing to the next slide. Under Section 70B of the Municipal Land Use Law, the Board of Adjustment also hears interpretations of the zoning ordinance. So that kind of comes about in municipalities where maybe you have an antiquated ordinance, or more likely you have some new technology or new ideas that really weren't contemplated when the ordinance was first drafted. Or maybe it's just that the terminology has changed and there's a question as to whether something that's kind of new in the world is covered as a permitted use or not a permitted use under the ordinance. And if that question does arise, whether something is permitted or not permitted, meaning does it go to the planning board or the Board of Adjustment, that interpretation would be made by the Board of Adjustment. And typically, an applicant who's requesting an interpretation would simultaneously file an application for a use variance. So that if they're here already and they have all their experts in there, they put their case on for the interpretation. If it doesn't go their way, they just slide right into their use variance application. You can go to the next slide. Under Section 70C of the Municipal Land Use Law, the Board of Adjustment also hears all the C variances. It's either a C1 or a C2, typically referred to as a bulk variance. Those variance applications are on notice to homeowners within 200 feet in all directions of the property, as well as to any utility companies that may have registered with the municipality to obtain those notices. That is by far, I would say, the larger part of the agenda items heard by the Board of Adjustment. And then the hard applications are the D variances that you started to hear about. Under Section 70D of the Municipal Land Use Law, as I said, the Board of Adjustment hears cases that are not otherwise permitted under the zoning, and there are 6 types of D variances. You know the next slide. So for each of these 6 types of D variances, for the application to be granted, the applicant would have to receive 5 affirmative votes from the board. So we do our best to provide a full board. I'm not aware of any case that says you absolutely have to, but I think that case is coming. And there someday will be a case that says, you know, board, you have thousands of people in your town, get 7 people to sit up there and hear this case. And there are some special rules that you'll hear about later about rules of necessity that allows us to go to the planning board to obtain some additional members to be able to put 7 people up there for a use variance, or a C variance for that matter. So anyway, the 6 types of uses, the D1 that you've heard of is a straight use variance where that particular use is just not permitted in the zone. So someone wants to put a retail center in a residential zone, or even a house in a industrial or a commercial zone. If it's not specifically permitted in the zone, it is a D1 use variance. Paul Phillips will review what some of the legal requirements are for the 6 Ds, and the D1, as you'll hear, is the hardest one for an applicant to prove. The D2 is if there is something that has pre-existed the current zoning. It's, you know, grandfathered essentially, and now the property owner wants to change that property and you know, just make it larger, technically even make it smaller, to the extent it changes the structure or even the use that was non-conforming. That is a D2 variance. The D3, which you heard a little about from Steve, the conditional use variance, if the applicant satisfies all of the conditions for a conditional use variance, it would go to the planning board. And if there's any of those conditions that are not entirely satisfied, it would go to the Board of Adjustment. And again, that applicant would be required to obtain 5 yes or affirmative votes for that application. The D4 variance is a floor area ratio variance. It is exactly what it sounds like. It is the square footage of the floors under the roof. So if you had a 3-floor building, all 3 floors count. It's different than what the footprint alone is of the building. So it's all of the interior square footage, often actually measured from outer wall to outer wall. And it is that ratio to the square footage of the lot. And for example, in Morris Township, I'm pretty sure the OL zone has a FAR of 25%. So if someone came in and wanted to put up a commercial building that exceeded the 25% ratio, that would be a D4 variance. And again, no matter, even if the use itself was permitted, it would come to the Board of Adjustment, and a D4 variance would require 5 affirmative votes because they wanted to make it bigger than what's otherwise permitted. And that's a way that any township can try and regulate how large a building might be on a particular lot. D5 variances are density variances, meaning a zone may, for example, allow 4 units to an acre, and they have a 2-acre parcel, so they would be, a developer would be permitted to build a building with 8 residential units, and so that would, let's say that would be permitted, but if they wanted 9 or 10 or 12 or anything above 8, that would be a D5 variance, and it would push them to the Board of Adjustment to obtain that vote, and again, of the requirement of having 5 affirmative votes for something that's larger than what's otherwise permitted in the zone. And the D6 variance would come into play if the building, whether it be a residential building, a single-family home, or a commercial home, if that building were either 10 feet taller than what's permitted in the zone or 10% taller. So if the zone, for example, allowed a 35-foot height, and in Morris Township we do measure right to the peak of the roof, if it exceeded it, so if it allowed a 35-foot height and they wanted to build a house that was more than I guess 38 and a half feet high, that'd be more than 10%. That would require them, even though it were permitted, to come to the Board of Adjustment to seek that extra height. And again, they'd be required to get 5 affirmative votes. One thing also that the Board of Adjustment does is once a year we'll prepare a report and submit that to the Township Committee and to the Planning Board and explain to them the types of applications that the board has heard over the last year, and more importantly, if there were any provisions within the zoning ordinance that the board felt should be addressed by the Township Committee, because the Board of Adjustment, while it interprets the ordinance, it doesn't write them. So if it thinks that something should be corrected, and again, new technologies are probably a perfect example of that, they would provide that annual report to the Township Committee and the Planning Board and say, hey guys, take a look at what we're doing in our ordinance now, because we're getting a lot of applications on something that maybe could be addressed with an ordinance change. So that happens once a year, typically at the end of the year or in January. So, okay, Paul Phillips is going to talk to you about variances. Just the one thing I think you need to remember about the Board of Adjustment is not everything fits in this square box. And so somebody needs to be there to adjust for that. And as it sounds, the Board of Adjustment does just that. Thank you.
Good evening. For those of you who do not know me, my name is Paul Phillips, and I serve as the Township Planner, the Planning Board Planner, and the Zoning Board Planner. So I have a lot on my plate, and I've served in that capacity in Morris Township for the past 8 years. And I'm going to talk about variances. So variances essentially are exceptions to the zoning regulations. And generally speaking, development should be accomplished by way of ordinance as opposed to by way of variance. But as we all know, the world isn't perfect, number one. And also there are often sort of unusual or extraordinary circumstances involving particular parcels of property where the granting of variance relief may indeed be warranted. The other thing from this slide I just want to point out, which I think is important, is that when a variance is granted, it runs with the land. And that's basically the third bullet. It continues to be in effect post the sale or other change of ownership of the property. So it runs with the land. It doesn't necessarily go with the applicant who appeared and was granted the variance at the time. So we have two types of variances you heard. There's a C variances and D variance. The C variances are essentially bulk type variances. By bulk type variances, these are variances from the zoning ordinance for things such as lot dimensions. You don't meet the minimum lot size requirement. You don't meet the minimum lot frontage requirement, the minimum depth requirement, the minimum width requirement. Those are dimensional type variances. You don't meet the setback requirement. You exceed the allowable building and impervious coverage requirements, all C variances. Height is a C variance unless you meet the trigger of a height D variance, which Rich talked about, I'll also talk about a bit. Signage is a C variance. Parking, want a relief from you don't meet the parking requirement. You have less spaces than is required. That is a C or bulk type variance. There are two bases for basically granting C variance relief. They're known as C1 and C2 criteria. The C1 criteria is basically a hardship variance, and the C2 criteria is what we planners and attorneys refer to as the flexible C criteria, and I'll get to that in a minute. So for the hardship variance, the relief essentially is based on hardship or some type of exceptional practical difficulty due to the unique physical characteristics of a piece of land or the structures that exist lawfully on that piece of land. Also, if you go to the next slide, the The hardship, or this is important, the hardship or practical difficulty must relate to the physical condition of the land or the property, and it may not be a personal hardship or a financial hardship to the property owner. It has to basically go back to the particulars of the property, which is part of the application before the board. Just some examples of classic C1 hardship variances. You have a lot that is exceptionally narrow lot. You can't meet the side yard setback because of the narrow lot on either one or both sides. You apply for a variance. Similarly, a shallow lot doesn't have a lot of depth from the public right-of-way. You may need a front yard or rear yard variance based on the dimensions of the lot, or sometimes you might need both. There are such environmental constraints. You have steep slopes and wetlands encumbering, let's say, 2/3 of a property, and you basically can only locate a structure on a portion of it that you might need a setback variance. These are all examples of classic hardship type variances. Also important to indicate that an applicant is only entitled to a hardship variance. Basically, you can't have something called self-created hardship. Let me give you an example of self-created hardship. An example would be that an applicant has a conforming lot and he comes in to subdivide that lot into 2 lots. And he could have basically met the zoning code if he went in for development on 1 lot, but he subdivided it for 2 lots, and now he or someone later down the chain comes in and is seeking variances on 1 or both of those smaller lots. So essentially, the property owner created his or her own hardship by subdividing and creating lots which can't meet the zoning requirements. Next. Let's skip successors and interest just because of time. The second type of C variance is the C2 variance, or the flexible C variance. These variances can be granted when the variance advances 1 or more of the purposes of zoning, which are basically set forth in the enabling statute, municipal land use law, and when the benefits of granting the variance, in other words, allowing the deviation from the standards, substantially outweigh any detriments. It's sort of a balancing test that basically needs to occur in order to come to that determination. The purposes of zoning are set forth. I think there's 16, or there may not be 17 purposes of zoning that are set forth in the MLUL, which is the enabling statute. Some of them, not all of them, are listed in the slide. And the ones that sort of come up more frequently than not are the first purpose, which is, excuse me, guiding development in a manner that, under A, promotes public health, safety, welfare. Another one that comes up is, which is shown there under D, but it's really purpose G of the statute. Actually, it's E, shown there as E, providing sufficient space in appropriate locations for a variety of uses. Typically, that's advanced for a particular use that the zoning may not provide for in the proper location. And also, aesthetics come into play, which is purpose I of the statute, which is listed as F there, promoting a desirable visual environment. Next slide. So an applicant also has to basically satisfy what's known as the negative criteria for C variance. Any variance, C or D, has to satisfy what's known as the negative criteria. There are 2 prongs to it. Essentially, the first prong of the negative criteria is that there be no substantial detriment to the public good. And the focus on that is the impact. More often than not, the focus is on the impact of the variance relief sought on the character of the surrounding neighborhood or immediately surrounding properties. And the key, if we can just go back to that, this is important. The key word here is the word substantial. Since all variances presumably have an impact, it may have some impact. If you have a vacant piece of land and you're going to build something, it's going to have an impact. The test is whether or not those impacts rise to the level of being substantial in nature, in terms of their detrimental impacts. And the ultimate determination of that, basically by the board, is fact-sensitive. And it's based on the particular circumstances at hand vis-a-vis the application that's before the board. The second prong of the test is no substantial impairment upon the zone plan or zoning ordinance. Again, the key word here is substantial, because any variance by its very nature would be contrary to the zoning ordinance. You're applying for an ordinance, it's not consistent with the zoning. So again, that has to rise to the level of being substantial in nature. And again, the test and ultimate determination is fact-sensitive based on the particular circumstances of the application at hand. I'd say one other thing in this regard: for a bulk-type variance, in satisfying this criteria, you basically may on a particular property be entitled for certain reasons for this bulk variance, but you basically have to demonstrate in so many words that in not having an impact on the zone plan, that the fact that there's a standard in place for other properties, that standard still makes sense for all the other properties. So you're not impacting the ultimate zone plan, you just have a unique circumstance where you may be entitled to relief. The D variances, Rich went through the 6 D variances. The D1 variance is the classic use variance. It's a use which isn't allowed in the underlying zone. An applicant for a use variance has to satisfy what's known as positive and negative criteria. On the positive criteria, special reasons have to be advanced. And there are 3 circumstances where the special reasons can basically be concluded or found. One is something referred to as an inherently beneficial use. An inherently beneficial use is a use such as a school, a hospital, an assisted living facility that by its very nature inherently promotes the public welfare. If you're an inherently beneficial use, you presumptively satisfy the positive criteria for a D variance, and you basically only have to satisfy the negative criteria, the impact portion. A second circumstance is that if you are so particularly suited, the use is so particularly suited for this site that it's going to basically promote the general welfare. That's a second case where special reasons can be found. And the last is undue hardship, where you would have to demonstrate that you really cannot utilize the property for any of the permitted uses within that zone district in which it is located. That is a very heavy burden. It is a very difficult test. Even the particular site suitability test can be a significant burden. And again, the inherently beneficial use presumptively satisfies the positive criteria. Let's go right to Medici. This is the negative criteria, the impact portion of the test. And very importantly, there was a 1987 New Jersey Supreme Court case that we referred to as Medici. And what that case did was, for non-inherently beneficial D1 use variance cases, it basically established an enhanced quality of proof. And it established basically a reconciliation test. And it said, in essence, said that the board, an applicant and the board, has to reconcile the fact that the zoning didn't envision or contemplate the use. And if that's the case, why should you be entitled to the zoning variance? It's a very heavy burden established by the Medici case. Basically saying, why should the board go against the legislative intent? So what are some circumstances where you can make that case? Well, change conditions. The character of the neighborhood has changed. An applicant has to demonstrate that it's changed since the zoning ordinance and the last master plan was put in place. Other things were built that weren't contemplated. Variances were changed the character of the district. Other changed circumstances, the zoning is 10 years old and it didn't take into account a new use that's come into play in the last 5 years. This is probably more than 5 years, but one of the things that often came up was like fitness gyms, fitness facilities, therapy, CrossFit facilities. Oh, the master plan is 10 years old, it didn't take that. That's a changed circumstances. That's a use that the governing body didn't know about and would not necessarily have precluded that use when it wrote the zoning regulations. Very heavy burden on an applicant to satisfy that Medici test. And again, all of these are fact sensitive and based on the circumstances of the case. D2 variance is expansion of a non-conforming use, and essentially this is, the D2 variance is a use that either was legally in effect prior to the zoning going into place or was granted a variance, so it basically was sanctioned at that particular property. There's a lesser burden of proof for a D2 type variance, and again, the focus on the D2 in the special reasons analysis, it only applies to the expansion or intensification, as opposed to having to go back and show that the use would have been entitled to the non-conforming status to begin with. Again, the focus again is on the intensification or the expansion. D3 conditional uses, Rich touched upon these. In many cases, the ordinance allows a use, but only if it meets particular conditions. And if it meets all the conditions, you go to the planning board. If it doesn't meet one or more of the specific conditions, it goes to the zoning board of adjustment. And the conditions could be things such as, for a particular use, a hotel, you need 5 acres. You only have 3 acres, zoning board. The buffer of 25 feet is required, you're only proposing 10, zoning board, you don't meet those conditions. And the burden of proof for a D variance is greater than the burden of proof for a C bulk variance. And that test for a conditional use variance comes out of a case called Coventry Square versus the Westwood Zoning Board of Adjustment. And indeed, it is a lesser standard in burden of proof than a D1 use variance. The reason being that the use is already contemplated there, you just don't meet the specific standards. And the test that was established by the court in Coventry was that an applicant has to show that the site can still accommodate the use, right? Notwithstanding the fact that it's deviating from these standards. So let's just take the minimum lot size example I gave. Ordinance says 5 acres for a hotel, you come in for 3 acres for the hotel. That applicant has to demonstrate to the board's satisfaction that that hotel and everything that goes with it, its parking, its buffers, its setbacks, can still function consistent with sound planning, notwithstanding the fact that it doesn't meet one or more of those particular standards. D4, Rich touched on this, floor area ratio is basically the relationship between the sum of all the areas of all floors within a building divided by the lot size. It basically is a zoning tool, a regulatory tool that's designed to control the intensity of use on a particular piece of property. Next, the test for a D4 variance comes out of another case called Randolph Town Center, and the court in that case basically adopted that same Coventry Square standard for the D3 variance. You need to show that the site can still accommodate the proposed use, notwithstanding that it's exceeding the floor area ratio. That's the test for a D4. D5, density variance. You're looking to build more dwelling units per acre than the zoning allows. The test, again, same coming out of the Coventry Square. These tests, even the D6, they're all the same. It's you still need to show that notwithstanding the fact that you exceed the density, that you can overcome all of these problems. Let me give you an example just where you might not be able to overcome the problems. You are seeking, the zoning allows a density of 6 units per acre, you're seeking 12 units per acre, but you're coming in with a plan that doesn't have enough parking to meet the 12 units per acre or can't provide the required buffer to the adjoining single-family homes. That would be a difficult case to make. You're not necessarily overcoming the problems associated with seeking a higher density than the zoning permits. And then lastly is the height variance, and these are for height variances that are either 10 feet or 10% more than what the zoning allows. If you're below that threshold, you're considered a C bulk variance for height. If you're above, it's a D variance. And again, these cases are different, Grasso versus Borough of Spring Lake Heights, but they're all adopting that same Coventry Square standard that you have to show that the site can accommodate, consistent with sound planning, the additional height that they are seeking above and beyond the zoning ordinance. And then the last part of my presentation is which board. So, the planning board. Subdivisions or site plans, or again, conforming conditional use applications, all go to the planning board with or without C variances. Total planning board function. Zoning board of adjustment will get just C variances, it gets D variances, or when there's a combination of the two. A C variance that goes to the zoning board for, let's say, a single-family homeowner that's proposing a deck expansion that's encroaching on a yard setback, that doesn't also require site plan approval. That's just a straight variance that the zoning board can grant. But subdivisions or site plans that have any D variance, right, including the D3, they go to the zoning board. So the ancillary powers of the zoning board to basically review subdivision and site plans comes when it's a D variance, because otherwise, without that D variance, it's a planning board function. So thank you for your time, and I'm going to turn it back over to Steve.
Actually, Rich is going to jump up next. I'll finish, but we got about, I'm sorry. Rich is going to start. I'm going to finish. We got about 15 more minutes, and then we'll go to questions when we're done. Thank you.
We're pretty much on time, I think. And I think you're all still here because of the benches and the people on the ends haven't left. Okay, so far, we've heard about the planning board and the board of adjustment and variances, and so now we're going to talk about the application process and how does an applicant actually get in front of one of those boards. So what happens is the applicant would get the actual application from either your website or from the board secretary, complete that, it would be submitted, and at some point in time that application would be deemed complete. And there's a whole process for the commercial stuff and use variances where the technical coordinating committee in town gets together and reviews that application and determines if it's complete or not. And once an application is deemed complete, there's 45 days for which, but there's a time limit. We have 45 days, sorry, there's 45 days for which we have to deem the application complete. So once it's complete, the applicant gets a hearing date from the board secretary, and the process then is that the applicant has to submit public notices to everyone within 200 feet in all directions and any utility companies that may have filed to get those notices. So they would get that certified list from the municipal tax assessor, and as long as they follow that list and they send that out certified mail, typically, with an affidavit later to follow to us before the first hearing, that would show and prove that they mailed out their notices. That notice also has to be published in the paper, the registered paper for the municipality, which again is the Daily Record of the Morris Newsby. There is actually no requirement that the people actually receive it. They just have to be mailed. So if you're not home and the mailman puts a sticker on your door and they put it in a slot and tell that sticker says to you, hey, you have certified mail, go pick it up. If you never pick it up, it's not the applicant's fault. If once they mail it, if the post office loses the mail, it's not the applicant's fault. So the law is that they have to mail it, not that you have to actually receive it. And it does have to be mailed and published in the paper at least 10 days before the hearing date. So now they have their application, they have their notices out, and who gets to represent them? Well, if you are an individual, you can represent yourself. If you're anything else, you can't. So if you're a corporation or an LLC or a partnership or any other type of entity, you have to be represented by a New Jersey licensed attorney. So the last two bullet points on this slide are really more, I think, board member notes. One thing is if a board member is going to do a site visit, because in the application itself there's a consent form where the applicant allows any board member or professional to visit the site and walk the property. And sometimes, many times, board members will do that. And when that occurs, the board member should state on the record that they saw the site and what it is they saw, because maybe not everyone got an opportunity to go see that site. And to the extent that you learn something or glean something from your site visit, it should be on the record so that everyone has the same amount of knowledge when it comes down to voting. And also you'll see that, there are other agencies that submit reports to each board, such as the Environmental Commission or the Historic Commission, and those reports would become part of the record and be noted that way as well. So procedurally, once you're here and you are presenting your application, or an applicant is presenting their application, the applicant always goes first. Their witnesses will testify. That testimony will be under oath. After each witness testifies for the applicant, the board will ask questions, after which the public will have an opportunity to ask questions of those witnesses, narrowed to what they testified about. And the applicant will typically, if they're represented by an attorney, will typically have the applicant speak first, tell the board what they want to do. Their engineer will speak, their architect will speak, and typically you'll find that the planner will go last. But after each of those witnesses, the procedure is the same, that the board asks questions, the public will ask questions. And after the applicant's witnesses are complete, any, we call them objectors, but you technically could be in favor of the application if you can. But any one member of the public could come in and make their statements as well. And at that point in time, you would be sworn in as well, because any statements you make to the board have to be under oath as well. After that is completed, then if an objector is represented by an attorney, that attorney will have an opportunity to make a summation. The applicant's attorney will have an opportunity to make a summation as well, and then the board would deliberate. Now, during the course of the application, jump to the next slide. The rules of evidence are somewhat relaxed. The board will not, however, permit petitions or letters. So if there's an application that you're concerned about and you want to write a letter and have the board look at your letter, that board will not be read at the hearing, because it really comes down to the board or the applicant's attorney can't cross-examine that piece of paper. And they may have questions based upon what you wrote in that letter. So if that were to occur, you could retain an attorney who could come in and represent you, but a letter by itself would not be accepted. Okay, again, under evidence, you'll see all experts do have to be qualified by the board, and essentially, if they are licensed in the state of New Jersey, they will most likely be accepted then. So when the board deliberates, that deliberation is up here and visible to everyone. That deliberation should be very detailed, and just a practice tip to board members, your rationale for voting yes or no, in favor or against an application, your reason should be very specific and placed on the record at either before or certainly at the time that you are voting, however you are voting. Ultimately, that decision will be reduced to writing in a resolution, typically at the next meeting, and then adopted by the board. That resolution then is published. The board secretary will publish it typically the next day or two. That date, the publication date, is very key, because the appeals are triggered off of the date that publication occurred, which is 45 days from publication of the resolution. And the entire resolution is not published, it's just a brief 2 or 3 line summary that the board took action on a certain application. But it's a key time, because under court rule, prerogative writ cases, which are what they're called in lieu of prerogative writ cases, are the appeals that are filed by, say, the losing side, and they are limited to 45 days from the date of that publication. And in Morris County, PW cases, prerogative writ cases, are heard by the assignment judge, who is currently Judge Minkowitz, would hear that case. Those cases typically are heard 6 to 9 months after they're filed, so it's not terribly long. And it is a bench trial, meaning there's no jury, and it is entirely based upon the record that is put before the board. There are transcripts submitted, all of the evidence that was marked is submitted, so the judge has everything as though he were here. He will read the transcript. Judge Stanton used to tell me he started off by reading the resolution first, and then they will read the transcripts and look at whatever evidence as is mentioned throughout the transcripts. The interesting, or I suppose beneficial part of representing the board on a PW appeal is that there's a presumption that the board acted correctly, and there's a very high burden to be overcome. The appellant would have to prove that the board acted arbitrarily, capriciously, or unreasonably in order to win their appeal, which is, again, a very, very high standard. And again, there's a presumption that the board acted correctly. During the course of the appeals, it is possible that you could settle with an applicant. For that to occur, however, it would be back on notice to all the people within 200 feet and back before the board for a public vote. And I think that we're now back to Steve.
I'm going to do ethics in 5 minutes or less. And we're going to get you that ethics credit. The conflicts of interest. Board members sometimes have conflicts of interest, and just like a judge, cannot hear an application. Generally, the standard is, do they have a direct or indirect personal or financial interest in the outcome of the matter? Okay? And if they have any of those, and those are some of the examples, they cannot hear the matter. There's a municipal land use law provision that addresses it. There's a local government ethics law that addresses it. They mirror image each other. One word's different. Instead of interest, it's involvement. Fairly minor distinction. Examples, as you might imagine, if you're within 200 feet, if a board member is within 200 feet of the property, they're by definition a very affected property owner, very interested in the outcome of the case. They're out. The family member within certain degrees of consanguinity or I always get confused on that one. Thank you. But if a board member's family member is involved, they're out. Employer, employee, business partner, they're out. If they're a member of an organization, and there's interesting case law, which I'll tell you about in the advanced class when you come back, for members of organizations, houses of worship, and the like, that you are out if you're very much involved and very active in the organization, the house of worship. Bottom line, I call it the gut check. You come to me if you're questioning as a board member whether or not you have a conflict of interest. You always go to the board attorney. And in the end, if I determine that you do not have a direct or indirect personal or financial interest, there's one more test you got to pass, and that's the gut check test. If the board member is not certain that he or she can decide the case objectively and impartially, purely based on the facts and the law before him or her, get out. When in doubt, step out. How do you step out? You recuse yourself as a board member and either go to the back corner of the room or, you know what, it's a volunteer job. Take the rest of the night off, perhaps. You don't have to announce the reasons why. The chairman does, or chairperson does not have to announce the reasons why, because as you might imagine, if the chairperson said, well, the board member, the board chair, the vice chair, the mayor in a planning board has a very direct and personal interest in this, it really does not, you could go too far. You could actually influence the outcome potentially of a decision of the board, or at least give that appearance of impropriety to the public by getting into too much detail as to why somebody's recusing themselves. So to me, less is more. What do you do when you don't have enough board members because of these recusals, the borrowing provisions? We used to have the rule of necessity. There was a case involved the Bay Head Yacht Club. And Bay Head, I guess, was a small municipality, and they had their board. The problem was the yacht club came before the board, and the real problem was, guess what? Everybody in town was a member of the yacht club. So, hence the rule of necessity. I don't like the rule of necessity. When you got to go to necessity, you're really stretching. So we got the borrowing provisions, which means that the volunteers of one board get to not only volunteer for their board, but get called upon if there are enough conflicts of interest on the other board that they need them to have to come over and do extra duty on a volunteer basis. Planning board and zoning board, and there's specific rules as to who gets the opportunity to go. And we've had that in our township, and again, I can't say it enough. The board members volunteer their time, and they volunteer their time and efforts sometimes on more than one board when called upon to do so. Continue. But guess what? As a board member, you don't lose your right as an individual citizen to have property rights and to care about your property. But there is this balance, like everything in municipal land use law and everything in life, perhaps there's a balance. So you don't lose your right to make your pitch for your land development application or object to the person who's immediately next door just because you also serve the public as a public official or a board member. But it's better to have a surrogate or someone else, an attorney, another family member, spouse, what have you, to serve in your place to minimize the appearance that you might be influencing your fellow board members by asking them to grant the application or deny the application. The Open Public Meeting Act applies to all the governing body as well as the Planning Board and Zoning Board. Our schedules are published in two newspapers at the beginning of the year, and we have to at least give 48 hours notice before any special meetings, and those things occur. There are time-sensitive matters that arise. All meetings are open. However, there are 7 limited exceptions. 9 limited exceptions. It's an old joke. I was wrong once. I thought I was mistaken, but actually I was incorrect. It's not a good joke, but it's an old one. The one that comes up most is number 7. Please move on. Pending or anticipated litigation or contract negotiations, as well as matters requiring attorney-client privilege communications. Sometimes the government business has to take place, including zoning board and planning board business, has to take place in an executive session for important, narrow reasons. And when those reasons for keeping that portion of the meeting closed or an executive session no longer exist, the litigation is over, and for example, in the period of time to appeal that litigation is over, well, now then those minutes of that executive session can be and will be released. I think at this point, I'm going to anoint everybody who stayed the entire time. You are now certified to serve as a zoning and/or planning board member. I'm going to look for your applications by, the next 5 minutes. But actually, you've already gotten the course, frankly, but you do have to take a 10-question multi-choice test in order to formally be certified. So I am only joking. But if you want to take that test, I'm happy to administer it, and you'll be ready to go on one or both of the boards. Now we're finally at the point to answer your questions, hopefully. So, and I'm gonna lean on my colleagues as well.
Do you have a mic?
Oh, yes, we do. I'm sorry. Amanda, do you mind? Thank you.
I'm so loud I probably don't need a mic. But my question is, maybe for Rich more than anyone else, but zoning board of adjustment decisions which are appealed in a typical year, if there is such a thing as a typical year, how many appeals would there be, and how often does the does the decision of the board prevail?
So I don't think there is a typical year because every application is so different. I can tell you now, I've been here, as I said, since 1997, and over that time, there's been only a handful of appeals. We have won all of those appeals, by the way.
No pressure.
Yeah, no pressure, but as I said, there's a pretty high standard for the person who's appealing to actually win. So of all those, we won them all, and I think one actually settled and we came back and made some changes.
Yeah, with those Whispering Woods settlements, normally what happens is that they don't get what they originally asked for. They get a modified version, and it's all public.
Hello, can you tell us what is meant by development and redevelopment? What do those two concepts mean?
I can...
Oh, and the third one was rehabilitation. So what do those three concepts mean?
Okay. Well, because you probably don't want another whole 2-hour course or more, I'm going to try to give you the abbreviated version, and then if my colleagues wish to jump in, please do. But development applications are before zoning boards and planning boards just to develop property in certain circumstances, multifamily, what have you. There is a separate statute, separate from the municipal land use law, called the Local Redevelopment and Housing Law. And under that statute, you can do redevelopments or rehabilitations under certain criteria for each. And if you establish that the area is either in need of redevelopment under certain criteria, which we can get to in a moment, or lesser criteria but in need of rehabilitation, then what you can do in essence is have a redevelopment plan, which some refer to as legal spot zoning, but you can set an ordinance for that particular tract of land and essentially almost collaboratively come up with a plan to zone that ultimately is still going to require not only a public hearing at the planning board for an area in need of redevelopment or rehabilitation designation, as well as other meetings, but also public hearings at the governing body level to adopt a redevelopment plan, which is that ordinance for that property, and third, another public hearing before the planning board to have a development application, essentially a site plan application, at the end of that road, if you will, for the redevelopment or rehabilitation, under the new redevelopment plan ordinance to have a site plan application in order to ensure that the application complies with that redevelopment plan, and where it doesn't, to consider whether or not relief is going to be granted from those deviations. So a redevelopment or rehabilitation process under a different statute, a longer process, frankly, and even more public hearings than a typical development process application. It allows, depending upon what the designation is, for certain additional opportunities for financing and the like for whoever might be the ultimate redeveloper or rehabilitator. With that, though, I'll turn back to the other two.
I think you've covered it.
I covered it. How do you like that, Malcolm? I did it in less than 2 hours, a little bit. And I hope I answered the question.
Thank you. Thank you all for your presentation. I have a few questions, so I'll ask 2 or 3 now, and then I'll pass it on to some others, and then come back to me perhaps. Number one, this is not with respect to your presentations tonight, but I've been to a number of meetings, as many people in this room have been, and the applicant walks in with an oak tag that no one can see. Very few of them have PowerPoint presentations. If the public is here to listen and to comment on it, we can't do it with a piece of oak tag or presentations. So I would just implore you to consider making that part of the requirements. We have planning companies and architects walking in with a piece of oak tag. To me, it's absurd. That's a comment, not a question. My question is, Is the Board of Adjustment's annual report made public? And if so, where would I find it?
You could ask Sonia Santiago is the board secretary. She would have it, and it is available to you.
But as far as you know, we can see that.
Yes.
Okay.
And if I could just jump in on that though, too, because I represent zoning boards as well, and so I know Rich feels the same way. The zoning board's annual report, to me, is a very critical document because, like the analogy to government that I made, you have the executive branch, the legislative branch, and the zoning board, often the quasi-judicial branch. They're seeing the results of the ordinances. And like any legislation, by the time it gets to the courts, if you will, and the people who are actually seeing most of the variance applications, they're best suited to say, hey, wait a minute, I don't know that this is exactly what the governing body and the planning board intended to capture these, types of applications that, that homeowners might have to spend a lot of money to come in to before the zoning board to hire professionals, etc., as an example. So that is a beautiful way, in my opinion at least, for the quasi-judicial body, the Zoning Board of Adjustment, to at least on an annual basis get its information, what it's seeing on the ground in the field, back to the decision makers, the policy makers, the governing body, and the planning board, and say, hey, you may want to rethink this and you may want to change that. Thank you for the opportunity.
And if I could add to your first comment, because you emailed me about that very specific thing about not being able to see.
Yes, I did.
The exhibits up here. We actually did bring it up at the planning board meeting this past Monday. Based on your comment, I brought it up at the planning board meeting, so thank you for that comment. And I asked Steve actually if we could look at requirements for having the applicants submit electronic versions of their plans so that the electronic versions can be submitted, projected onto the wall, just like we're doing now.
Yeah.
So we're going to be looking into that.
Absolutely.
Thank you for that comment.
Yeah, we don't have carte blanche to require them to do everything we'd like them to do, but we do have some authority, and we're going to use all that authority.
Great, thank you. Legally, does the Board of Adjustments need to listen to every aspect of an applicant's presentation, even if they are not meeting their major burden of proof on some of the items that are conveyed early on? In other words, someone comes in with a whole list of variances. Some of them are, now see what I've learned, some of them are D variances with high burdens of proof, and that's early on. Does the board have to listen to the entire applicant's presentation?
Absolutely, yes. We can't shut them down and say, we don't think, we think we're not going to like what you have to say, so we're going to send you home. We have to listen to their entire presentation, because although when they first started, maybe they didn't meet their burden, but if they keep going, by the time they get to the end, they may have. So we are completely obligated to listen to the entire application.
And under the municipal land use law, just like judges, to make an analogy, have to hear cases before them and give a full fair opportunity to the parties presenting that case, the Board of Adjustment and the Planning Board, for that matter, when hearing out land development applications, cannot prejudge cases. So it is an obligation, mandatory.
And I'd like to add a twist to that question that was just asked, and I'll ask Mr. Aller to answer. Is the township required to listen to any application that is put forth by a developer, no matter how crazy it might be? If they wanted to build an amusement park, across the street, are we required to listen to the application?
There's no question you are absolutely required to listen to the application. You don't have to, at the end, agree or approve it, but you have to listen to it. We've had people come to Board of Adjustment meetings in the past, and not just here, in other towns too, and ask the same question. It's like, why are you even listening to this? It's preposterous. We're completely obligated to listen.
There's a body of case law, and it is definitive, TWC Realty being the primary case, but several others. If an applicant has standing, significant interest in the property owner, tenant, etc., and they bring the application procedurally properly to the right board with the right fees and plans and everything on the checklists, The board must hear the application and the whole application and decide that application, essentially no matter what the merits may or may not be.
So that was one takeaway I wanted for the public tonight, because I've gotten a lot of emails in my first 3 months as mayor about why the township is even engaging with some of the projects that are out there. And I just want everybody to understand that it's a requirement. You know, if somebody wants to do something with their land and they want to spend the money to go through the application process, because there are a lot of fees involved. There's application fees and engineer fees and drawing fees. If they want to pay all that money, we're required to listen to them.
And if I can dovetail on the dovetail there, and in addition to those fees that the applicants have to pay, it is a user fee system. They have to pay escrows for the board professionals, attorney, planner, engineer. So the general public, we township residents, and I can say we township residents are not paying for our taxes for that. It is a user fee. The applicant, homeowner or developer who is bringing the application pays for everybody, if you will. So it is a particularly steep economic burden to bring an application, but what the merits are, if they bring it, we got to hear it.
Yeah, let me triple dovetail. I think lawyers
A lot of dovetails.
well, it's a good question, and I've heard it in many municipalities, and you know, lawyers don't guarantee anything ever, but I would guarantee that if we sent someone away because we just didn't want to hear what they had to say, that we would be sued and we would lose. You know, it doesn't mean that they would get what they wanted in court. At a minimum, the judge would send it back to be heard. And at a maximum, I've seen judges appoint masters, and the master takes over that case and hears that case. And that's the last thing you really want to have happen. So we would certainly hear it and decide it.
Just to continue the dovetails, but one thing we do get, it's the municipal land use law. And we as municipalities, we get preempted a lot, right, by the county, by the state, by the federal government. But one area in New Jersey with home rule, we as a municipality get the most control and the most direct control of the land development in our municipality, in our township. So it's important that we keep that control and not have it go to a special master or a judge or someone other than us. That's why we have a citizen zoning board and planning board.
And I'm going to add one more thing, which is my second takeaway that I wanted from the public tonight. And it relates to what Mr. Aller just said about going to court. A lot of people have emailed me that as mayor, you know, why can't you weigh in on items that are before the Board of Adjustment? And you heard tonight that the Board of Adjustment is an independent body. If any council member, not just the mayor, but if any council were to publicly give an opinion about that application that might unduly influence people who have been appointed by the mayor to the Board of Adjustment, that would give grounds, if I'm correct, to the applicant to take it to a court, because the governing body has tried to influence an independent body, and that would be grounds to take it to court. So I just want the public to understand that even though I might have an opinion about certain development projects that are before the Board of Adjustment, I can't publicly speak about it. It would be to the detriment of the township, because it would put us in a legal situation. Is that correct?
And that
Is
goes
that
for
correct,
any,
guys?
It would be
absolutely, yeah.
It would be worse.
It would be worse.
Yeah, and that holds true for every governing body member as well. Question in the back.
Going back to the question on redevelopment, you said you have to see if there's a need for redevelopment. Whose need is that? Is that the municipality or the person who owns the property?
Not a need, if I may, but certain criteria. The first step in the process under the local redevelopment housing law is for for a determination to be made as to whether or not a particular piece of property meets one or more of the criteria to have it designated as an area in need of redevelopment or an area in need of rehabilitation. But the word need wasn't intended to mean somebody needs it or somebody doesn't need it. It's an area, the area is statutorily under certain criteria, either in need of redevelopment or rehabilitation or not.
What are the criteria?
And who makes, just for clarification, who makes that determination?
The planning board makes that determination in the context of a public hearing.
But it comes up from.
But can I jump in?
Please.
But the ultimate determination is made by the governing body.
Correct, it's right.
So the,
Of the actual redevelopment plan?
no, of whether or not it meet, let me try to explain this. So there's something called the local redevelopment and housing law in New Jersey. And essentially, the way it works, as Steve mentioned, is if a town wants to undertake an investigation to see whether or not any property or properties meet what's considered to be an area in need of redevelopment, the governing body basically directs the planning board to undertake an investigation of that property or properties to determine whether or not it meets specific criteria in the statute to qualify as an area in need of redevelopment. I'm just going to give you some examples of what this is. If you got areas that have substandard buildings, if you have areas where buildings that were previously commercially used, that use has been discontinued, if you have areas where you have buildings or structures that are poorly laid out or functionally obsolescent, that would qualify. If you have vacant land that has been vacant for 10 years or more and there's issues with its location or its access or topography that's really prevented it from being development, you could use the tools available through the redevelopment law. So what happens is that once the governing body directs the planning board to undertake the study, the planning board does that study. It's required under statute to hold a public hearing as to whether or not that property qualifies. The public, as in any public hearing, can get up and speak and question and make comments. And then ultimately, after the public hearing held at the planning board makes a recommendation to the governing body as to whether they believe it meets the criteria or not. But ultimately, the determination is made by the governing body under that enabling statute.
Does this have to be?
If I may, I did misspeak. I said the planning board makes the determination. They do hear the study in the public hearing, and they do render a recommendation, and through the resolution to the governing body then decides whether it endorses and accepts that recommendation or not. Please continue.
Is that the process initiated by the property owner or by the township or municipality itself?
Well, ultimately, the only way the process can move forward is that the governing body has to basically direct the planning board to undertake the study. It's a governing body action that prompts the planning board to do the investigation.
Okay, thank you.
You're welcome.
And if I could dovetail on that again, because redevelopment has come up a couple times, and you guys can weigh in. So the difference between a redevelopment process and a traditional land use process is something would go to either the planning board or the board of adjustment, depending on the path that was taken. In the case of a redevelopment plan, the governing body is the land use board in that specific case. They review the plans.
So the way it works is that let's assume that there is an affirmative declaration that the property qualifies based on the statutory criteria. The next step is that a redevelopment plan is prepared. And the redevelopment plan is typically much more detailed than a zoning ordinance. It's a, can be a 20, some case 70-page document that goes into things such as design standards, things that you don't typically find in the zoning ordinance. And those are safeguards that are designed to protect the public interest and basically assure that there's quality development on that property. But it's basically, in lay terms, it's very glorified zoning. And similar to zoning ordinance, it's the governing body would basically introduce the redevelopment plan as it would introduce an ordinance at a first reading. It then goes to the planning board for referral, just like a zoning ordinance would. The planning board gets to comment on whether it's consistent with the master plan, and it also can make any other comments on the redevelopment plan that it wants to make back to the governing body. And then the governing body holds a public hearing at second reading, just like an ordinance. And then the governing body can either adopt or reject that redevelopment plan at the public hearing second reading. If it's adopted, then what happens is that a property owner can make an application for development to the planning board, similar to site plan approval, and that application is based on all the regulations and standards that are in the redevelopment plan. And then the planning board hears that application, and there may be relief sought in that application from the standards of the redevelopment plan, similar to the C variances that we're talking about today. Typically, and I've drafted a lot of redevelopment plans on behalf of municipal clients, typically in the redevelopment plan you basically say any change that someone is seeking that rises to the level of a D, one of those 6D variances, cannot go to the zoning board. And basically, if you want any change in that redevelopment plan that rises to a height, beyond the 10%, 10 feet, or the floor area ratio, the density, that can only be done by the governing body based on an amendment to the redevelopment plan. So the point is this redevelopment plan is a significant document for significant properties. You don't want it, no offense, but you don't want it going to the zoning board.
No, that's true. That's why I said before, there's sort of three. But there's the area in need of redevelopment designation phase, which has its own public hearings. And if it keeps going, the redevelopment plan phase with its own public hearings. And if it keeps going, the site plan application phase with its own public hearings. In essence, 3 phases of meetings and public hearings in that process, longer than a typical land development application. I'm sorry, man.
No, that's okay. So just to close the loop, because there's been some questions that it came up earlier tonight because the Township Committee had a special meeting regarding an area in need of redevelopment, and so there was a little bit of discussion there. But just to close the loop on that, the reason I brought up the question earlier about the Board of Adjustment and anybody being able to bring any application they so desire, as long as they're willing to pay the fees, they can bring any application they want to the Board of Adjustment to be heard. The redevelopment process is I don't know if you want to call it a higher standard, but it's a much more rigorous process in order to get approval on a property that you wouldn't have to go through if you were going straight out to the Board of Adjustment and leaving it to this independent body to decide on. So I just wanted to close that loop based on the discussion earlier, that the option exists for the landowner that for an area in need of redevelopment to just go straight to the Board of Adjustment if they wanted to.
Sure.
Right?
Right.
Yeah.
When you talked about the 10-day notice requirement, I caught my attention because I
Just get a
thought,
microphone if you want.
do I need it?
I doubt it. But no, you did. You're good. I wish I could project like that.
I have wondered in the past whether that comes from the municipal land use law. I presume it does. And could the township adopt a stricter standard requiring a longer period?
Answers are yes, it does, and no, we can't.
Why? Is it preempted?
The municipal land use law governs what we do as a municipality, yes. In essence, we're preempted by the municipal land use law in that respect.
The second question that I have has to do with appeals. And I presume that your discussion and your PowerPoint slides of pertaining to appeals are from both boards.
That's correct.
And what is the right or the procedure of an objector or an adjacent property owner who's adversely affected by a decision to appeal? Does he commence an action in Superior Court, or how is that done?
Yes, if you are a person with standing, which is loosely described as you live in town.
And possibly even not.
Yeah, right. And so if you have standing, you can file an appeal from either board. That appeal would get filed in the Superior Court in Morristown. If you're in Morris Township, right, it would go to Morristown because it stays in the county. And then, as I said, Judge Minkowitz, who is currently the assignment judge, would hear that case.
Right. And in essence, what happens, those of you who are familiar with litigation, normally you start at the trial court level with the trial court judge or jury, and appeals go to what's called the appellate division, and then possibly even to the New Jersey Supreme Court, or possibly even beyond, maybe even the U.S. Supreme Court. But here, we, as a zoning board and a planning board, are administrative bodies. So appeals of our decisions actually go to the first level of the courthouse, the Superior Court for our vicinage, our county, Morris County.
And can I ask one more question? It only peripherally pertains to the presentation, but does the planning board have the authority or right to dictate standards for construction? And what I mean by that is that I've noticed that recent development of multifamily housing in Morris Township is large. I can't think of a better word, but if you look at what's happened to the Honeywell property, it's very, very large. Whereas in Madison, I've noticed for years with admiration that their public housing, lower income housing, seems to be much, much smaller buildings interspersed throughout various neighborhoods. Is that something that a planning board can mandate?
It might take another couple hours, I don't know, but I think generally, for example, you mentioned one that...
Yes, no, or I don't know is good enough, but seriously.
I'll give you a fourth answer, maybe. We had a particular, you mentioned Honeywell, that was a general development plan, that was a long process, some of which preceded my involvement here, but that was in essence a type of specialized zoning application to the board. When you're getting into, there's only so much control, and defer to Paul, I think, because it's a very general question. The answer is maybe. We have some authority generally, but not carte blanche, I guess is the bottom line to sum it up.
Well, the only thing I add is, each municipality's situation is different, particularly with regard to its affordable housing obligations. Each municipality has a different context in terms of how much vacant land is available. I mean, all these things weigh in, and I can't answer specifically although I'm familiar to some extent with development in Madison. I'm not as familiar as I am with Morris Township. It's sort of difficult to answer, and a lot of things weigh into, why a development or zoning is put in place. It's kind of hard to answer that in a vacuum, to be perfectly honest with you.
But if you were here in the fall, Paul did, with a little bit of help from the rest of us, a phenomenal, in my opinion, presentation on affordable housing, and specifically why we did and were able to do what we did, notwithstanding all the unfortunate circumstances with the courts handling affordable housing now. We did our best, level best, and were successful in minimizing the density, the heights, etc., that were required in order to meet our affordable housing obligation here in this township. And frankly, everybody, not just the professionals, even more so the governing body members, and everybody involved played a big part in that. But every municipality just about right now out of the 565 throughout New Jersey are going through a similar process, and frankly, many are not, believe it or not, faring as well or doing as well as we did.
That's not exactly what I mean, though. I did mention affordable housing, but and you cautioned at the beginning not to get into specific cases, so you don't have to comment on the specific case, but as an example, what's being proposed by the Madison Hotel, for example, is a very large building. Whereas when I look at the development in Madison on Ridgedale Avenue and Cook Avenue, the multi-family houses or townhouses, but they fit the character of the neighborhood. They're certain story, I think they're two-story houses. They look like houses. They're beautiful. And that's really what I mean. I threw in the words affordable housing, but that's not the thrust of the question. The question is, can the planning board say, we want a certain type of construction here?
You want to answer that? You want me to jump in?
Let me just, because we can't talk about cases that are presently
Don't
before
address those two
board.
cases. It's a general question.
But you brought it up by example, and my response back is, yes, there's a proposal before the board, and the board is going to weigh the merits, because it's a quasi-judicial body. He's going to weigh the merits of that application and ultimately make a determination. this town had basically couldn't do anything about it. An applicant made an application, as you've heard, the zoning board has to hear that particular application. And the board will hear the application and deliberate and decide.
But one thing about use, one thing about use variances is, remember, it's a use that's not permitted in the zone. So the zone doesn't really have any standards for what's to be built. So there's nothing for anyone to look at.
That's my question.
Right, so
Could you do that in internal? That's the answer.
Yeah, the answer is no, because it's a use variance. They're coming in with a blank slate. It's simply not permitted in that zone. So that zone, when you go to the book and you open up your, the municipal zoning book and you look at the standards for that zone, it's going to talk about other stuff than what they're proposing. So it doesn't really apply to what that applicant, in any application for that, would want, right? So you really can't say, well, this is what's permitted in this particular zone, and if you're going to come in with a use variance for, some other item, this is what we want. You wouldn't typically ever do that. It's just a blank slate.
And to answer your question about the affordable housing component, and you see this all over the state of New Jersey, not just here. There were mandates by the court last year. Everybody negotiated what their settlements are going to be about how many affordable units they need to put into their communities. And some communities are still battling with the court as to what their final number was. We got a fairly good judgment because the professionals did some great work. But we have this burden. I don't want to call it a burden because I think affordable housing really does have a place in our society, but we have this mandate to put affordable housing into the community. And given the vacant lands that we have, and this is what everybody's doing, there's only limited places right now to put them unless you can build one or two at a time where houses are. If you want to reach the numbers that are required in the next 6 years to build those units, you are finding that they're clustering them because that's the easy way to meet this mandate. I'm not saying that's the best way, and I can tell you from my perspective as the mayor, I'm trying to alleviate that and trying to make it not clustered as much as we can by looking at ways we can spread it out a little bit and not making things so dense. But that's the reason why you're seeing proposals like that are clustering all the affordable housing here in Morris Township, but all over the state of New Jersey. It's not just happening.
Madison is clearly building them in small units in small places on smaller lots, and it looks a lot better. And I think from the point of view of integrating the social classes, it's also better as well.
I would agree, and perhaps they planned a little bit better.
I think they did.
Maybe they saw it coming. I don't know. I don't know their reasons for doing it.
Every municipality, there were other questions here, and I don't want to
Yeah, exactly. Thanks.
to leave anyone out. There was a question over here. There's a microphone coming if it helps.
Well, I don't know. I'm
Can you stand up, ma'am?
Yeah, I'm distressed. I get the impression that the builder or the applicant has the majority of the law on their side. Now, you say they have all these different DEC and variances, but if they work hard about it, they can overcome that. Well, what I'm kind of trying to say is that we moved into this area for reasons because it met our criteria as to where we wanted to live. But it's changing, and change is good, sometimes change is bad. But I don't think the public has input on this. And I'm more concerned about the Honeywell property than anything. I mean, if you talk about low-income housing, why didn't it go in there?
There is low-income housing that's there. There's 24 units, I think.
24 units out of how many? But anyway, what I kind of wanted to say is I just don't think the public has much to say. The permits can be changed, and the zoning can be changed. I mean, we spent tens of thousands of dollars making up a zoning plan, and then somebody comes in and they want to change it, and they do.
Well, if I would say these standards are the standards, and the members of the planning board and the zoning board, they're not them, they're you. They're members of the public, and everyone's invited and welcome. And, you know, you take the 10-point multiple choice question, I think you might be qualified. If not, even if you didn't take that test. But under those standards, with the guidance of the various professionals, every case is different. When I teach this course to the board members, I use the analogy of a snowflake. To me, every snowflake looks the same. But that's why I'm a lawyer. But a good lawyer will make every snowflake different, I guess. But the point is that apparently every snowflake is different. And so even if an application might look like another application, there are so many dynamics to every piece of property, where they're located, etc. The point is every case is fact specific. If they meet their burden of proof for the relief they're seeking, as we said before, first, the board has to hear the case if they have standing and bring the application. And secondly, if they meet the board burden of proof, the determination may well be that that development can occur with those conditions. And again, who's making that determination? It's not them, in my opinion. I started as a municipal, I was a governing body member many, many years ago, before I became a municipal land use lawyer. It's us. It's we residents, because we're the ones on the board. All residents on the zoning board and on our planning board, all residents, and only 2 of which are members of the governing body. So it's in essence, for lack of a better term, it's a trial by a jury of their peers.
And if I could add to the Honeywell situation, and I'm not saying this, I think people in the public know I didn't really agree with what ultimately happened at Honeywell, but the history of it is that they came in with a much more intense plan than what ultimately got developed. They originally came in with asking for a hotel and maybe a continuing care retirement community, plus apartments, and what it got scaled back to is what you see today. And that was again, I was not on the planning board, I was not involved in those negotiations, but sometimes, am I correct, sometimes it is a negotiation, the planning board says, no, we're not going to go there, but then you ask them to scale back a plan and they come back with something new, and at some point, if you just keep on rejecting them, they're just going to take it to court. Is that correct?
And if I recall correctly, and again, I wasn't involved, but I do know some of the history, and I should defer, but there was litigation involved. So there were denials, and I believe, and litigation involved. So it was a process, not just one of applications and not just one of negotiation, but one of litigation. But others might know more than I do.
The only thing, just to piggyback on the mayor's comments, is that that was a fairly lengthy process. And the original proposal included a hotel. It included continuing care facility with assisted living, and also it had, in addition to townhouses, it was either stack flats or multifamily, and it was scaled back to the residential portion to townhouses at a very low density within that townhouse section of, I think, about 4 units per acre, which is actually lower than the density of some of the established townhouse developments, long-established townhouse developments in Morris Township.
Well, they're not stupid. You ask for X, expecting only Y. I mean, the hotel was probably the only income tax, I don't know.
Does an appeal from a board decision stay the execution of the board decision?
An appeal, well, yes. If it's a denial, there is no execution to be taken, I guess. But if there's a grant and an objector appeals in a timely fashion with a prerogative writ action to the Superior Court, yes, it would stay the
Only if the appellant asks for the stay, right? Which they typically would do. And the reality is it does serve that way, because if you're the person who just got that approval and you know it's being appealed, you're not going to take the chance of building your development while it's under appeal. So it has that effect, but unless they ask for the stay, they can technically build it.
Any disgruntled objector who wants to appeal is going to ask for the stay, not just rely on the economics of it to effectively get a stay. I'm sorry, there's one question here and one question there.
I have a question. Is there any limit to the amount of time or number of times a person can appeal? Because I'm thinking, a person with deep pockets, building a hotel, building an entire estate, can go on and on and on and bleed their opponents dry. What is the limit? Is there any limit?
There is a limit, and if you bring a prerogative writ appeal to the Superior Court and you do not win, whether you're the applicant who was denied or the objector who wants to, is disgruntled by the approval, they can, as of right, appeal, whoever, if you don't win, so to speak, at the trial court level on the initial prerogative writ appeal, you can appeal to the appellate division. After that, like any other case, the Supreme Court of New Jersey will only take cases on what's called a petition for certification. So rare is the short answer. And U.S. Supreme Court, as we probably all know, even rarer. So they're probably only going to get to whoever's appealing. If they don't get their way, so to speak, at the trial court appellate level, they're probably only going to get to go up to the appellate division appellate level, and that's where it ends. And I'll throw one more in. We're in the advanced class now, too, so be careful. But there's something called res judicata, which means if somebody brings an application and it gets denied, they can't come back a month or two later with the same or essentially the same application. They're barred. So you don't get second and third bites at the apple either.
Also, I'm kind of suspicious. You offer something that you know you're never going to get, and you're going to compromise at what you really want. That's...
People might do that, but you know what? If they're not entitled to even what their compromise is that they really want, effectively they're not going to get it. So.
I just have a question about the advisory boards to the planning board and the zoning board of adjustment. What kind of weight do they have in the decision making in something like a redevelopment zone? They had any say or any weight?
I can start the answer, but I'm going to look behind me for a finish.
Do you want to clarify just what you mean by an advisory board?
The Environmental Commission, the Open Space Commission,
Oh, okay.
the
Well,
Historic Preservation Commission.
Sure. There are certain commissions that are advisory, like certain historic preservation commissions could be a historic preservation commission or a historic preservation advisory commission. Advisory can only, make recommendations, but for all intents and purposes, all these bodies, these commissions, make recommendations. The ultimate determination on a land development application is the zoning board or the planning board that's hearing it. But in a regular land development application, so to speak, generally what happens is many of the recommendations made by Environmental Commission, Historic Preservation Commission, what have you, turn into conditions of approval if there's going to be an approval. So it is an important function, and we didn't have time to get into the interrelationship between the commissions and the land use boards. But that's basically where it goes. Now, as far as redevelopment is concerned, that's a different situation, and just generally, as was explained before, that's a zoning process, not a development application process, at least initially. But correct me if I'm wrong, Paul, I don't think there's anything stopping a commission from weighing in at the site plan approval level, even after there is an area in need, say, of redevelopment designation and then a redevelopment plan that's adopted by the governing body. Once you get to that site plan application process, sort of third in the three phases I laid out, I believe, correct me if I'm wrong, that commissions can weigh in. That's correct, and the commissions wouldn't necessarily weigh in at all when the study's being undertaken, because that's very specialized, and it really kind of takes a trained professional to do the investigation, who's familiar with the application of the statutory criteria. I think those advisory boards would come more into play, as Steve suggested, similar to any site plan application, where the Environmental Commission often, for example, weighs in before the planning board in Morris Township. There would be no difference, and that advisory board could certainly weigh in on a development application that is advancing a redevelopment plan, just like a site plan that's inconsistent with what the underlying zoning provides.
And just to clarify also, any written opinion by one of those advisory boards, the Board of the Environmental Commission or the Historical Preservation Commission and such, would be part of the public record of the application, right, and available to the public to view. So if there was a specific recommendation, the public would be knowledgeable about that.
Correct, absolutely. Right here, and then right back there.
You mentioned res judicata,
Uh-oh.
and I probably know the answer, but I think everybody should understand. So if an applicant, property owner, came to the planning board or the zoning board and was denied, you said that they would have to wait a certain amount of time. Could you just clarify for all of us what that amount of time is and what they would be allowed to do with their plan to come back quicker?
Sure. I didn't technically say they had to wait a certain amount of time. And unfortunately, I can't clarify, because it's not specifically quantifiable, how much time they would have to wait or how much different their application would have to be. This is a body of law that's somewhat equitable and it's somewhat vague. And you can go through the hundreds or more cases, and frankly, you can come up with sort of kind of an idea, It's very generalized, but the bottom line is there has to be a period of time, first of all, primarily the basis of which, and Paul, our planner, can correct me if I'm wrong, generally it's assumed that over time there might be more changes occurring both on the lot in the area, as well as even perhaps in the zoning ordinances and site plan and subdivision ordinances. So that temporal aspect, that time frame extending, is something that, in essence, the longer you wait, the more likely you might not be barred from bringing an application under the doctrine of res judicata. But also, the more different, that's better than differenter, isn't it? The more different your application is, the better, or more likely you are to not be barred by res judicata. But it's a little vague, and those are the concepts you're looking for. And frankly, I'm sure you'll say the same thing, Rich. Board members, don't make that decision without advice from your board attorney. Make him or her give you a legal opinion, and make him or her, take the responsibility of that determination, because it's very hard to determine and very fact specific. But the more different the application and the longer the time frame away from your initial bringing it, the more likely you're going to be to get over the res judicata bar, or the less likely you are to be prevented from bringing that application under that bar. I hope that made sense.
I agree. It's, res judicata is not ever really an easy call. But I do think the amount of time that has passed, is certainly one of the things that a reviewing board would consider. Because just as a municipality, if a board denied an application, 25 years ago, you wouldn't want to say 25 years later that you could never really develop what today might be a good idea that wasn't a good idea 25 years ago, based on the passage of time and changes in surrounding uses to the property. So there really is no case that says, after X number of years, it doesn't apply anymore. Right, so time is a factor that the board would consider, and then any modifications to the plan is something that the board would consider.
Can I complicate this? Put you two guys on the spot? Because, it's a legal issue, but I'm involved, as you know, and this issue has come up before the zoning board. But time obviously is not the only factor, and as you said, Rich, it's the weight and the magnitude of the change from the prior application to the new application. And I've seen in my experience and recent experience where an applicant actually made significant changes to a plan that was denied, and the board basically said you can surpass this res judicata hurdle, even though that application may have been made within a year of the denial.
Oh, absolutely.
So time is just one of the factors, Joe.
Any other? There was another, I think.
Thank you. One of your slides indicated that neighboring towns are notified of certain projects, and I have a two-part question. What kinds of projects determine that the neighboring towns get notified of? And two, what efforts does the Township of Morris make to coordinate huge development projects, more than one house, with neighboring towns and the county? Because I think there's so much outrage, because if you look at Forum Park's development, Madison's development, Morristown's development, and the township's development, it's overwhelming the people who, like this woman said, chose to come out here and live because it was a bucolic neighborhood and peaceful and calm, and now we're not seeing that anymore. So what efforts does the township make, because that's all you can speak to coordinate that?
Well, I'll handle the notice part first. So any application for development that requires notice to surrounding property owners, if the property is within 200 feet of the neighboring municipality, the notice, that the certified list that you get from the assessor will say that it is within 200 feet of whichever town, and that you have to obtain your second list from that municipality as well.
And notify that other municipality and the residents who are within 200 feet
So
in
it's
that other
only
municipality.
towns that are within 200 feet
Correct.
of the applicant's request?
Correct.
That's for a land development application in and of itself.
Right.
There are other things, as I mentioned before, any changes to master plans and other things that the planning board does. Notice goes to adjoining clerks of adjoining municipalities, as well changes to the ordinance, clerks of adjoining municipalities, as well as I said, the county and the state. And the county also gets notification and has approval powers, as I said earlier, over certain types of site plan and subdivision applications as well. We in Morris Township, I can speak from personal knowledge, we have a system where when those notices come to our clerk, they immediately go to the appropriate board and governing body. If it's a master plan change being made in a neighboring, adjoining municipality, we get it, the governing body gets it, the planning board gets it, the planning board professionals get it, and we review it and we do what we can as being interested parties as a municipality. So we track them and do what we can with respect to the changes in the ordinances in the neighboring municipalities, the changes in the master plans in the neighboring municipalities, and those land development applications that are close enough to our border for us to get the notice, we can and sometimes do weigh in and take action.
And with respect to the coordination with the county, when there is a site plan, a major site plan application filed or a major subdivision application filed, there's always a simultaneous application filed with the county that the municipality would know that that occurred. We'd actually get a copy of that to know that that occurred. And when the county issues their review letter, the municipality is always copied on that. So we always have the county's comments to the application as well.
Thank you.
And the applicant has to get the county's approval in addition. That's one of the additional agency approvals that they have to get. So they do have to get the county approval too.
And just to add on to that, and this is my personal opinion, we might not agree with things that are going on, and I certainly don't agree with a lot of things that are going on in Florham Park along the Park Avenue corridor. But a lot of times municipalities don't weigh in on other people's businesses because we're really separate entities. That could change, but where I personally see the big breakdown is at the county level. You know, the Park Avenue is a county corridor. It goes through multiple towns that need to coordinate with each other. And my personal opinion, just my personal opinion, is that there's been a failure by the county to help plan properly along that Park Avenue corridor. and it's resulted in what you see. With that said, we've finally, just this past week, got an agreement from a whole bunch of people from Madison, from Florham Park, Morris Township, NJDOT, and a couple other agencies to finally sit down at a table and talk about Park Avenue. It's because I asked Mayor Conley if he would be willing to do that, and he and I worked together to facilitate that meeting. Mikey Sherrill's going to be there, our Congresswoman's going to be there at that meeting. But yeah, in my opinion, this has been a failure by the county to properly, they have the county planning department, and I don't think that they've properly planned for that corridor specifically.
Thank you. One more point, if I can be indulged, is we have all the boards here, we have the mayor here, we have interested citizens here, and we want to know how we get our voices heard. At least I want to know. Because we come to the meetings, the amount of time for the presentations is this long, the amount of times for questions is this long, and we often feel that we're not being heard. So how can we do a better job of making our voices heard?
So I think with respect to the Board of Adjustment anyway, it's always been my experience that the Board of Adjustment has given great deference to neighbors and when they have something to say. The only time, that there might be some limitation is to cut down on repetition, but any member of the public has an opportunity, particularly at the end of an application when it's your turn. If you remember, I went through the procedure of who goes first and in what order. When it's your turn to say whatever you want to say, that is your opportunity. That's your best opportunity. Because up until then, it's, the applicant goes first and they put their application in, their witnesses testify. You have the opportunity to ask questions limited to what they testified to. Comments are not taken then because you're not under oath then either. So you have the opportunity to ask questions about anything that they testify to as they're going along, witness by witness. And at the end, you have an opportunity to present whatever you would like to say in opinion. At that time, you're under oath as well. So it's testimony to the board. And that's really your best time. You will also have the opportunity, if there's a group of neighbors who feel so strongly, you can hire your own professional and bring in a planner to object essentially to
Yes, it's
other.
costly.
Now, wait. We
I'm not
did
saying you
that,
have to, but
and our
that's an
objector
opportunity.
was not heard, was not invited to speak.
But before I speak to the planning board, I think the mayor wanted to address your question, so let me defer to the mayor first.
Yeah, so what Rich Aller just said is very correct for the Board of Adjustment because they hear specific applications and testimony has to be related to that specific application or that specific witness who's testifying. Something that we've implemented at the planning board, and I should say, as was discussed earlier, the mayor is allowed to appoint himself to the planning board. So I have taken on that responsibility. In addition to being the mayor, I put myself on the planning board because it matters that much to me, and it's one of the reasons why we're here tonight. Planning is very important to me. So I put myself on the planning board. One thing that we implemented this year at the planning board is we've added an agenda item that hasn't been done before, but we've added it at every meeting to have public commentary at the end of the meeting. So we could be discussing a specific application, or we could be discussing zoning that night or master plan that night. But at the end of the night, I wanted an opportunity for the public to come out and comment on anything they wanted to say related to planning. And that is now an agenda item at the planning board. So if you're ever concerned about planning issues in Morris Township, you now have that opportunity at the planning board to come out. Even if you're not interested in whatever specifically the planning board's doing that night, you can come out and speak at the end of the meeting about whatever you want to speak about related to planning in Morris Township.
Mayor's absolutely correct, and also just to say that what Rich described with zoning board applications is the same, in my opinion, with planning board applications. It's very expensive to hire professionals. When neighbors frankly group together, there's not only strength in numbers, but economically, it could strengthen as well. But also, your testimony is critically important, and that's why you're sworn. I know sometimes people say, "Why? I'm just a member of the public. Why do you keep making me give my name and address, and why do you keep trying to swear me in, Steve?" And the answer is so that you can give testimony that actually, if need be, if there's an appeal in court, hold up. And you can bring pictures, and you can bring the most important thing you have, frankly, which is your knowledge of the immediate area, and particularly, in particular, of the property in question that's being sought to be developed a certain way and get variances or what have you. Because just like the courts recognize that the most important people involved in determining any land use case are the citizens, the residents of the municipality who sit on the board to decide it, and give those board members great deference, the court does, if someone is foolish enough to appeal one of our good decisions. Then, so too, is tremendous deference and respect given to members of the public who are just like the residents on the dais with the unenviable job of having to make that decision. What you have to say is critically important, because the judges know, and they're told as appellate judges, that we have a presumption we're correct, in large part because we're the citizens as a board, the residents of the community, but also the judges know, and the law, the municipal land use law and the cases say, and I'm paraphrasing, nobody knows better than the members of the public the impact that development is going to have on the members of the public, particularly those within 200 feet who are generally the most affected neighbors. So make your testimony, bring your pictures, bring your knowledge, pool together. If you can, bring professionals, because it's difficult. The standards are such that if all the experts say one thing and there's no expert saying the opposite, I got the law to defend a board decision that goes the opposite way. I better. But it's tougher. I'm sorry, I get passionate. Yes.
I have a geography question.
Is there a mic? Oh, it went over there? Did you ever get your... You got it.
to ask the question.
Well,
Oh, he didn't get it.
you want to ask your question first?
Do you want...
Too late. It's okay.
Okay.
We'll get you next.
Please stay.
I have a geography question. It's not working.
Can you hold the mic to your mouth, please?
Yes.
There might be a button on the bottom.
I think.
Thank you.
At the bottom.
Thank you. This is really directed, I guess, to Mr. Phillips. When in the planning boards, do you have experts on topography? In other words, I asked somebody who's an expert in ground, in water-based soil. We are at the lowest level in Morris County. We had an issue with water. When it rains, it's marshland, a lot of places. Now, every time you build something, you cannot put a catch basin next to it. Where does the water run off when you build and you build and you build? I know even on Woodland Avenue, in a bad storm, this road is closed because the water has nowhere to run. You have to be aware of that when you're building.
So this is sort of more an engineering question, but I'll try and take it from Jim Slade. So yes, stormwater management is a concern of any applicant and a concern of any board member, and potential impacts on neighboring properties. And again, it's fact sensitive. Some areas may not have the same drainage or potential flooding issues as others. And certainly it is up to the applicant to basically provide sufficient evidence that they are not going to basically aggravate any particular flooding. They have to meet certain stormwater management regulations, local and state, which were basically put in place, and they're still sort of being modified as we speak.
And we're talking about those new proposed stormwater rules at the planning board, so feel free to come.
And those are basically designed to ensure that development basically controls runoff to the point at which it's not going to cause impacts on surrounding properties. With regard to site plan applications, applicants are required to address stormwater management. For major applications, they do reports that are this thick, and I'm glad I'm not Jim Slate because he gets to review them because he's the expert and I'm not.
And they have
Jim-
operations manuals that are this thick
and
and go along with them.
But does anybody read them?
And
Yes.
Jim will, and Jim understands the various different areas of the township as well as anyone. He's been the municipal engineer for some time. He knows areas that are prone to flooding. And I can say, for sitting next to him on applications as the board professional, he will comment on these issues and enlighten both the applicant and the board as to when there are concerns. And he will basically ensure that applicants address concerns, hopefully to the satisfaction of not only the board, but to the public.
Stormwater runoff, rates of flow, and volume of flow, groundwater recharge, which impacts, based on the permeability of the soil, impacts the quality of the water, et cetera, et cetera. And we have Jim, we also, the township is very proactive. For certain major development applications, we have specialized consultants who focus their engineering knowledge and expertise only on stormwater. Only on stormwater. Joe Scupian, I believe is his name, who has an outfit, and we will bring him in on those applications, just like we do for certain major applications. We'll bring in traffic engineers. Jim is a phenomenal engineer and is expert on all those areas. But we go so far as a township on certain applications when we need them to even just go beyond Jim, to still have Jim thankfully, but to go beyond and get the stormwater engineering experts and the traffic engineering experts of the world. And including, if need be, hydrologists, I believe it is, for soil permeability and the like.
That's what I thought.
So it's addressed.
And if you're interested in hearing about stormwater, the applicant, and I'm not going to speak any specifics about the application, but there's an application before the planning board this Monday for the Subaru dealership on Ridge Hill Avenue that's expanding. And part of the positive criteria that they're putting forward is that better stormwater management of runoff from that property. And I believe they're going to be speaking of, we didn't get to it yet, so I believe they're going to be speaking about that Monday, if you're interested in hearing about runoff and how it's dealt with at the planning board.
We finally got to you.
Water runoff is a fascinating issue, but I have a more macro question for the mayor. You added an agenda item to the planning board for us public to stand up and say something. Can you advise us on what the best approach would be to the planning board on one of these occasions? If, for example, we as a group or I individually wanted to ask about something like the convent station area, the traffic predicaments that we have, the build-up in traffic on Park, etc. It's a neighborhood question more than it is certainly a specific development issue. But it would be nice if we could approach the planning board with some advice on how to prepare for that presentation, etc. Having been through these sessions before with the Board of Adjustment and others, one's very conscious that there's a right way to do these things and a wrong way to do these things, and there's a productive way to present your case. Could you point us in some direction or to some person who could coach us if we want to bring an issue like that, a very macro issue, in front of the planning board?
Thank you for the question. So, people who have known me know that I really do seek public input. The people who live in the neighborhoods have the best knowledge about what goes on in those neighborhoods. You know, if you come out and tell us about cut-through traffic, you know, if I don't live in your neighborhood, I don't know about the cut-through traffic. I don't know about traffic patterns that people use. I know, for example, driving, you know, I, like many drivers, will go the shortest route, the easiest route, and if that means going down somebody's, you know, public street, I might do that. But having that information would be a very important piece of knowledge. In terms of how to present that to the planning board, I would think that if you could prepare some kind of document outlining the issues would be the best first step. And you could float that by myself and maybe have Jim Slate weigh in about how better to flesh that out or add more details to it. And then you could certainly, I would think, bring that, you know, send that to the planning board and say, we plan on speaking, give them prior notice. We plan on coming to the planning board on such and such a date to speak about this issue, and then we can actually plan for it and leave a slot of time for you to speak at the public session. Would be very helpful. Do you have anything more to add to that?
Well, I was just going to say, I think, as the mayor was saying, anything you can provide in advance for review by the professionals so that they are more prepared to give you answers would be very helpful. I certainly remember you appearing at the Board of Adjustment on at least one application that was probably there over 2 years that was near your home. And when it was your turn, I thought what you presented was probably one of the better, most prepared presentations from a member of the public that I've seen. So do that.
I think you just got a lot of business. But, and I'm going to defer to others in a moment, but I think a part of the process to make it most effective and efficient for everybody is because as Board of Professionals, we can't necessarily have carte blanche because there's charges involved to be practical. So certainly the governing body and the chair of the particular board, and I would probably the township administrator and or Jim Slade as the engineer for both boards should be in the loop of that process so that we can be authorized, frankly, to spend our time and effort, on behalf of that issue. I think, but I'll leave that administrative aspect to the administration.
Just as an example, my very first planning board meeting, I was so excited to be on the planning board. I got on the planning board and I said, I want to talk about signs, right, at the very first meeting. And the professionals turned to me and said, we're very happy to talk about signs, but we just can't do it tonight because we weren't prepared to talk about signs and we want to refresh ourselves with the rules and regulations and such. So they asked me to talk about it at the next meeting. And it's the same kind of thing. So if you can prepare us for what you want to talk about and give us as much detail about it, we can be prepared to answer the questions, and we're very happy to do so. And if you're talking about specific neighborhood issues, for example, if you live in Convent Station and something might come up related to the application before the Board of Adjustment, we might say that we can't go there, but at least we'll know that in advance, and you'll know that in advance if we feel there's any conflict in discussing a certain particular aspect of what you wanted to bring forth. Giving us the heads up would allow us to prepare that way as well.
Thank you. So is it the case I can look historically at what kind of issues are being brought in front of the planning board vis-a-vis a neighborhood? Meaning, is there a history of these cases being brought forward, or is what you just instituted the first?
I want to kind of cut in here because I feel like we're kind of going down the wrong road. I don't know if the planning board is the right forum for that type of thing. I'd say if there was like a traffic issue or a neighborhood issue, it should really come to my office, and if there's an issue, related to a signal or bypass traffic or those sort of things, sometimes the county gets involved, or the police department gets involved, and we'll do traffic studies or look at timing issues with a signal. The planning board has kind of a limited amount of time, and they're charged with handling applications. I mean, there's times when the load is lighter, so there may be the opportunity for more, public input, and, there's, I think on certain issues, it may be better to come to my office and we talk about it, and if it is something that might be helpful for the whole planning board to hear, I'm going to say, hey, that's a good one to bring up, during a public
Jim,
meeting.
We love you dearly, and you've certainly contributed much information and advice over the years, but I must be misinterpreting then what the mayor is saying in terms of these agenda items if we've got an issue. So what would be the distinction between that kind of come forward?
So what I suggested initially is if you could write up some detail and send it to myself and to Mr. Slade, and then we can help make the determination about what the best approach would be. Whether it's for the engineering department to take a look at it first, whether it's a township committee issue about an overall issue, or it's a planning board issue. But having that detail up front and sending it to myself and to Mr. Slade and Mr. Quinn, I think is the appropriate first step, and we can help you vet it to the proper place. You will always have that opportunity to make a comment in the public commentary session at the planning board or the township committee. But having the details will help you. I mean, we're going to be here to assist you in getting the answers.
Thank you. One last question. When is the first occasion going to be then for the planning board to have one of these agenda items come up?
We initiated it with the second meeting of the year. So at the very first meeting, I stated that I wanted an agenda item added to the planning board, and it was added at the next meeting. So there's going to be a planning board agenda issued tomorrow, and it was held up because of what the township committee was considering tonight, so they didn't publish the planning board agenda. Normally they would come out today, but they held it for tomorrow, pending on what happened tonight at the special meeting. But if you look at the planning board agenda tomorrow, it should, and if it doesn't, I'll have it added. Public commentary at the very end. Just open public commentary.
Right. Okay.
And that meeting is this Monday, April 1st.
No fooling. Sorry, there's no barometer. Yes.
If we're done, I'd like to just add something to this. I've sat on the planning board here for 17 years, and I learned a lot tonight, and I'm sure you all did too. But just think how lucky we are in our township to have 3 experts like this who were not stumped at all tonight and did such a great job. And to me, Grazel, thank you so much, very, very much, and everybody for coming. This is what it's all about. This is Morris Township.
Good job.
Just to echo Committee Member Kisa's comments, I have a very high standard. I do. I don't know if you can tell. But these guys who we have up here are really, really good. Jim Slade also, the professional staff we have here is really good. And we're lucky to have them as a resource. So thank you guys for doing what you did tonight. Great presentation. Thank everybody for coming out.
Good job.
And please come out to other public meetings. Come to the planning board, come to the township committee. We want to hear from you. Thank you.